Okay.
This meeting is
I
being
was looking for
recorded.
Tracy Lynn. If you are in here at some point, just let me know, like raise your hand or something. She might be running late. But I wanted her to give her testimony. She
Yeah, I do not see her.
actually from the do not pay, do not collect status video with the wonderful step that needs to be created based off of 328.6. She did it with American Express. She followed the directions. She did remember to pay the taxes with the 10-cent postal stamp. And she sent in the top portion, as we discussed within that particular class. She stamped it properly, and they paid her bill for it. That was American Express. So she's actually sent it, and she read her information as she was supposed to, and she did not send it to the trustee. She based it off of their terms and conditions when it speaks about payments. And it stated that if you have to send your payment or any other instrument is the words that they use. If you've been in this class for a minute, hopefully by now you know what an instrument is. If you don't, you might want to go look it up. But they said any other instrument to send to this particular address. She followed the directions. She sent it in. Her American Express bill is paid. So if she comes into the room, I don't know if she's just in this room or if she's in my private banking class too, but she's definitely on breakout. Y'all can ask Tracy yourself and she'll let you know that. It has been done. She sent one to Wells Fargo. Wells Fargo gave her just a little bit more backlash. You know, they're questioning her, asking her who the hell told her this information. But you know, I like to advise you guys of other people, you know, winning, because if one win, we all win. And just to give you a little bit of encouragement, because this process can be very intimidating. We're so used to conforming. So this process can be very intimidating, but just to see other people are winning, should just let you know that it works. You just gotta do it. Get like Nike, just do it. So that's that. If everybody will just, Caleb had a birthday while we were all gone. And if everybody can just wish him a happy birthday, that would be absolutely awesome. You can put it in the chat, you can wave your hand.
Happy
Happy
birthday.
birthday, bro.
Happy birthday,
Birthday.
Happy birthday, bro.
Hugs and kisses.
For a better person
Yeah.
to assist
Happy lunar return.
helping other
Birthday to
people
you.
Yeah.
get
Happy birthday.
fucking free. So happy fucking
21,
birthday to
right?
you, baby.
21.
So, on that note, we here for arbitration. Okay. Now this is going to be a two-part class. The reason it's going to be a two-part class is this. I've been doing this long enough to know that if I gave you guys everything sitting here for 4 or 5 hours, because that's how long it would take to get it all to you, somebody is going to immediately tomorrow go and file arbitration, and then you ain't gonna know what the hell to do. And then you're gonna be ringing my phone, and Caleb's trying to figure out what am I supposed to do, and I'm not going to set y'all up for failure like that. Y'all know I'm not gonna set y'all up for failure like that, because let me tell you something when it comes to arbitration, okay? You got a one-shot chance. Ain't no appeal, ain't no I'm moving to federal, it ain't no none of that. Oh no, none. You lose, you can't go back. Period. I'm not gonna set y'all up for failure like that. The good thing about arbitration though, because even though it is a judicial proceeding, it's not a formal judicial proceeding. You know, people like me and Caleb can actually go on your call with you as your consultant under the arbitration law and do everything and speak for you. And all you gotta do is sign a piece of paper. Let me tell you something else about arbitration, guys, because everybody like to put their whole life on social media. Everybody. You want to run and tell and the whole 9 yards. But arbitration has a confidentiality agreement attached to every last one of them. You post it, you lose. You can't even tell me, well, I'm gonna know you won. And I ain't even gonna ask you. I'm like, shit, I find you, good job. You know what I'm saying? Because I'm not gonna sacrifice, because you will. It is, and this is why you don't hear, this is why you don't hear so many cases when it comes to arbitration, because it's sealed. It's not no finding it. And you can't talk about it and they can't either. So it's not that these companies is just getting away with everything. You don't know unless they took it in as a federal lawsuit. You don't know if people are winning or not, but I will tell you they winning. I will also tell you that if you are rooted and grounded in the proper foundation, arbitration is where you get everything that you are lawfully supposed to have. Not just a little bit. Don't just go for, oh, I want my down payment back. Be like, nah, I know that the security agreement was the actual whole deal in this, and the car was a perk. So I need my check for the full balance of this contract. Plus I need, that's when you get to throwing in everything else. Because yes, even though arbitration is a one-shot deal, y'all just heard me say that. I'm going to show you guys that. But because I know, and now y'all know, that lawfully, anytime you're dealing with a security under Title 12, it is an automatic federal case. So yeah, there are things that you could do to, even if you do lose the arbitration and take it federal due to fraud, but it's going to take much more for you to do that when you can just get it done through arbitration. The first thing that we all have to step away from, and so many people say it, like, how many people in this room, and I want you to be honest because I can't help you if I don't know. Hold on. Because I think that it'd be like rude that y'all be in the chat like talking. And so now y'all can't talk in the chat. Come on, y'all get it together. Y'all that been me for a minute, y'all already know how I get that. If y'all new here, let me make a disclaimer, okay? I am one of the most bluntest persons that you're gonna ever meet, okay? I'm not gonna hold you up. I'll call you out, but let me tell you what else I'll do. I'm gonna stand 10 toes down with you. I'm gonna make sure that I help you to get the foundation that you're supposed to have in order to conquer these people. I don't have as many people showing that they're doing these things because I don't know what I'm talking about. Respect the fact that I am trying to assist y'all, and I think that is rude. Okay, thank you. So, due to the fact that under Title 12, yes, you can take them straight to federal court. You can even take them to chancery court. You notice most of these corporations is headquartered in Delaware. Delaware got the best contract laws you can ever think of. It's also a private state, but chancery court is there. We are dealing with equity. Even with arbitration, it's equity. It's equity in law. But if you don't know the law, you're gonna lose your arbitration. And you have to remember that when you go to arbitration, even though you have an arbitrary person there, you're going up against Audi, the mortgage company, you're going up against their attorneys, and they will try to, so you have to be prepared to do that. Okay, so my first question is, and if it's so, just raise your hand. How many of y'all think y'all the creditor? No, we ain't shy here. We all pass family. It is what it is. If you think that you are the creditor, raise your hand, because today you're gonna learn who you are.
I think it depends on the situation, doesn't it?
That's right.
No, you're the surety.
Yeah,
We're
in
on
some
it.
situations you don't want to be the creditor.
Right.
You use subrogation.
Awful lot of you guys in here. Okay, so you wear a lot of hats. Y'all can put your hands down for me, please. Thank you. You do wear all, but when it comes to consumer credit contracts, right? So I'm gonna make a statement, and I want y'all to tell me what you think after I say what I say. If under 18 U.S.C. 8, the United States is responsible for all debt. Debt. You want to be a creditor or debtor?
Debtor.
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 I want one person who would think, and I want one person who's gonna tell me it's gonna be a debtor, and I want to understand your thought process. Shannon.
Me?
Got your hand up. Okay.
Sorry, I
Omni?
couldn't get it to unmute. Yeah, you're the debtor at that point because you want them paying your debt. You want the government
You
paying your
gotta
debt.
unmute yourself, dog.
Could you hear that?
Why do you want to?
I did hear it, yes.
You keep muting yourself.
Thanks.
So just think about it. We have to use, common sense doing this. If they are responsible for all of the debts, you will be a debtor. Now, is there a point in time that you are the creditor? Yes, it is, right? It just depends on what situation you are in to know what hat that you're going to wear, right? So when you're on the regular side of the bank, you're acting as an agent for the straw man. When you're on the private side of the bank, you're acting as beneficiary and co-trustee, right? I'll say it again because I know I said it a little fast. When you are on the private side, you're acting as beneficiary and co-trustee. On the public side, you're acting as agent for the straw man. So for some of you guys that have been with me for a minute, you know that there's a difference in a promissory note and a certificate of indebtedness. A promissory note is what you do on the public side. The certificate of indebtedness is what it is on the private side when it goes through the Treasury. The Treasury don't know what a promissory note is. What they do know is what a certificate of indebtedness is. And that's how they got most people. You can't use one blanket thing depending on the law that you're using. So if y'all don't remember nothing else tonight, remember that when you are dealing with consumer credit contracts, you are the debtor, and I'm gonna prove it to you guys in just a minute. Okay. So the first thing that in order for you to get a successful arbitration and for you to win, you got to read the contract. Stop starting in Title 15. Go read the contract first. Because when I tell you that these people will tell you absolutely everything, oh, sweetie, I'm sorry. I had to take her address out. Oh, no, let me roll this up. That's my bad, sweetie. Don't mind me trying to go over there because I'll come try to pick you down. Not just looking, or am I? Okay, so the first thing that we are going to do is we're going to read the contract. How many of you guys have actually read your contract? I think you can unmute yourself. I don't think I got to say it like that. Mojo, when did you read it? Is the question. Mojo, when did you read your contract?
I read my contract a while back. I've been had my contract.
You unmuted.
Oh, do you hear me? Hello?
Hey,
Can you hear me?
Shaquita. Hey, Shaquita girl. Shaquita.
Hey,
Hi.
Caleb, I
Read your
don't think
contract.
Tamika can hear anybody.
She can't hear anybody. She cutting people off.
At all. Yes. Okay. Okay, give me one. Auntie, can you hear me?
Not hearing anybody.
Okay, yeah. That's definitely not working. Hold on.
Oh, okay.
I can hear Caleb and
Shaquita, are
I
you
can
talking?
hear Tamika.
Jamel, say something for me.
Can you hear me? Can you hear me?
I can hear you. I don't think she can hear you. Hold on.
Yeah, I don't think so.
I can hear you now. I can hear you now. Okay.
Okay. I
Yeah,
think
I
she
wasn't
can hear
hearing
you.
nobody. I'm like,
They messing
nobody
with
talking to
Zoom.
me. Yeah, Zoom.
They
See,
fucking
let me
with
tell y'all
Zoom.
something. I ain't had no issue. So hold on. Hey, let me tell my kids
I
to bring
can
me my
hear you.
stage stick because I'm not having it tonight.
I can hear all of y'all.
So y'all
I
can
don't know
hear
if
me,
y'all
right?
can hear
Okay.
me, but they fucking
Yeah,
with
I can.
Zoom tonight.
You really low. That's crazy. My really low. And my volume is all the way up. So as long as y'all can hear me, I'm okay. So y'all can hear me. Shake your hand.
Yes.
Okay.
Yes.
So that's what matters. Okay. So Shaquita, when did you look at your contract?
I looked at my contract when I was having issues with my creditor.
So when you went and signed for it, you didn't read it, right?
No, I didn't read it. And I took his word for it for the amount that he charged me for, which was different than the advertised price.
Mm. I can believe that's dealer fraud.
It
That's
is.
dealer. That's absolutely dealer's fraud. But if y'all look at the top of all of your contracts, it says that the car dealership was the seller, the creditor, right? That's what it says. And in that position, it says seller, right? But the law
Yes.
says that they are just credit arrangers. Credit arrangers. They arrange based off of those that are signed under them, the different banks that they have contracts with as acting trustee. That's all they have. They have banks. So you know how you'll go to one place and they be like, oh, we don't accept Capital One because they not having a contract with that bank. So that's step number one. That's the first fraud right there, is within the contract, because how can they say that they are the seller and the creditor if they are nothing but credit arrangers? That's it. Okay. So can y'all see the contract I got up? Anybody say yes?
Yes.
Okay.
Yes.
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 So thank you. We are going to, because you can't go to arbitration with these people until you break down the contract. Okay, so starting at the top, we know that I forgot to take her address out, but y'all know it says a consumer credit contract at the top. So that right there is them already admitting to the fact that this is a consumer contract, right? So let's get started. So it's saying that you, the buyer and co-buyer, if any, may buy the vehicle below for cash or credit. By signing this contract, you use to buy the vehicle on credit under the arrangements in this contract. You agree to pay the seller / creditor. See, so now they the seller and the creditor, but what credit did they give you? If they're nothing but credit arrangers. A creditor means that they actually physically gave you something. Okay, let's keep going. Sometimes we or us in this contract, the amount finance and finance charge in U.S. funds according to the payment schedule below. We will figure your finance charge on a daily basis. But now if you read, the finance charge is nothing but the interest rate. And if that's supposed to be annually, according to the Truth in Lending Act, how are they charging you a finance charge on a daily basis if its interest rates are annual? But okay, keep going. And then they have the audacity to tell you the truth in lending disclosures below are a part of this contract, right? So you can't really tell because this is a copy, but if you guys look on your contract, do you notice that where it talks about the truth in lending disclosures below are a part of this contract? Is it or is it not bold and in a different font? It's bold though, correct? Anybody who got their original?
Correct.
Okay, so y'all see Serena just said it's bold. Now look at this box. Isn't this box bold too?
Yes, it's a separate contract on a paper.
There you go. So what that meant was only thing in bold is what goes together. So they're telling you that under truth in lending, this is all the information right here. Okay, this box right here, I'm sorry. This box right here. This is what they're saying that's in bold. That will correspond with this right here. Okay, so here go to the year, all of that, VIN number. But here we go here. Okay. Personal, family, or household, unless otherwise indicated below. So why did they put in A? Why did they say it's not applicable? How can it be if at the top of here, it already says that, oh, it's not at the bottom, that it is a consumer credit contract if they're giving it to you on credit. But we do know that consumer credit is for personal, family, household use. So that's right here, should not be, that should say yes, okay? Now let's go down to the truth in lending disclosures. Now, If you see up here, they just told you that they're going to charge you a finance charge on a daily basis. Why does the Truth in Lending Act say it's annual? Because the annual percentage rate is nothing but the percentage of what the finance charge is. So how are you doing it on your credit as a yearly rate, but then you just said up there you're doing it daily, right? So then this is what the finance charge says, the amount financed, total of payments, total sale price, okay? I'll have it for you guys next week because I did not have time. I'm going to show you, or if anyone has one where you just went and got a bill of sale from the car dealership. That paper looks nothing like this. And then this full amount right here, which is these two amounts, the finance charge and the amount finance added together. When you walk into a dealership and say, hey, I got my own outside financing, I need you to create me a bill of sale. That bill of sale is going to have all of the numbers with the car, how much everything is. And then at the bottom, it's going to say finance charge, $32,635. It's also going to be in parentheses. And if you know anything about numbers, anything in parentheses means a credit. So when you guys are calling your finance company, not the dealership, okay? When you guys call your finance company and you're asking for a copy of the contract, do not ask for a copy of the consumer credit contract. Do not ask for a copy of the retail installment agreement. Tell them you want the bill of sale. Okay. So it's telling you about the payments and all that good stuff. But look right here. This should be on every last one of you guys' contract. Thank Trump. This actually went into effect in 2019, that on all consumer credit contracts, they had to input this right here. And it says, notice, any holder of this consumer credit contract, but wait a minute. If consumer credit means for personal, family, household use, but they put in A, but then they just turned around and told you that it was for a consumer credit contract. Okay.
Mine
So
doesn't show that.
Go ahead.
I'm sorry. Mine doesn't show the notice part.
It's in there. It may not be right there. It's in there. You have to read the entire contract out. It's in there. It's on another page, but I can guarantee you.
It's in
Yep,
there, but
sometimes
mine
it's
was
towards
on
the end
page
of the
5.
contract.
Because some people got it on a different page, but I
Yeah,
promise
page 5.
Yeah, I see mine.
that is there. So now
I've asked my car dealership as well as the finance company for the bill of sales, but they keep telling me that the retail installment contract is all that is the only contract that they have. There is no receipt, there's no invoice, there's no nothing. And I mean, I've gone to the Motor Bureau of Vehicles. I've called, Wells Fargo's bank because they're listed as a collateral holder on my contract, and nobody can give me a bill of sales or a receipt of purchase for the vehicle that I currently own. I have the title to it. It's been transferred over, everything, but nobody can give me the receipt or the bill of sales. So I'm kind of stuck on what I should do to get that bill of sales, to kind of show the other side of what you're talking about.
okay. So back to what I was saying.
Yes, sis. I'm reading this now. Yeah. It's definitely on here, sis.
So yeah. Any holder of this consumer credit contract is subject to all claims and defenses, which the debtor, so all y'all talking about you creditor, if you the creditor, you can't bring any claims or defenses if you're the creditor. It clearly states that you are the debtor, in which the debtor could assert against the seller of goods or services obtained pursuant hereto or with the proceeds means here of recovery, hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. All right. So now let me show y'all something. Y'all still see the contract screen, or you see this Cornell law screen? Sometimes I have to stop it.
Cornell law.
Okay, so let's get to these definitions. Number one, anytime you're looking up any particular title, if there is a next there, keep hitting next until it ends. Stop just be finding your one little thing, like, okay, there it is. No, if it's a next button there, it's there for a reason. Every time you come on their law, the very first thing they're going to give you is a definition. And I will tell you this, that if you ever want to get as close, as good as me, you better know every definition. And let me tell you something, the federal government definitions, from the state to the court definitions, to the bank definitions, they can all use the word account and they all mean something different. It's not what Black law say. Is depending on the chapter and depending on the corporation entity and what it is that you're doing. Because you have to remember across the board, from the federal government on down, unless it's Department of Homeland Security, everything else is a subsidiary corporation that works for the IRS, which works for the IMF. They're all of them. They're all corporations. So that's why when y'all trying to use certain laws in certain situations, it doesn't apply, because how can it? They're not using law. They're using policy. Everywhere you go, what do they say? Our policy says. So guess what? Go and then use the laws for natural consumers, for natural people, which is the consumers, and then you use that to back you up to help you against the corporations. So back to the definitions. We all know what a person is. We know what a consumer is, a natural person who seeks or acquire goods or services for personal, family, or household use. So now you see why they deliberately didn't check that button, right? But we keep going. Creditor. Once again, y'all didn't believe me. A creditor only when we're talking about consumer credit contracts says a person who in the ordinary course of business lends purchase money or finances the sale of goods or services to consumers on a deferred payment basis, because you never pay your person note, right? It's delayed for 30 days. So that means it's deferred. Provided such person is not acting for the purposes of a particular transaction in the capacity of a credit card issuer. So it just lets you know, person means corporation, or any other business organization. So how are you the creditor, not unless you're a business and you lend purchase money orders? Okay, so purchase money loan is actually what transpired in that consumer credit contract deal, which is a cash advance, which is received by the consumer. So let's back it up. And y'all heard me say that the amount that's on the contract is actually what you were supposed to get, and the car was a perk. The amount of the house was really what you were supposed to get. They were supposed to exchange you a check for your security. What is the security? The contract, right? Fair exchange had never been what? No robbery. So they made you think that the car was the exchange. No, that's unequal. It doesn't work that way. You was actually supposed to get a check. The car was a perk. The house was a perk, right? So because they did it as a money purchase loan, a cash advance, which is received by the consumer. Did any of y'all get cash at your deals? Anybody? No.
Nope.
In return for a finance charge within the meaning of the Truth in Lending and Regulations, right? So this I'm not gonna read the whole thing, but it's 16 CFR 433.1. Then we're gonna go to what a contract is. Let's go back to financing, a sale, extending credit to a consumer in connection with the credit sale within the meaning of the Truth in Lending Act. So now we know they got to comply with the Truth in Lending Act because that's all they're talking about. Then with the contract, a oral or written agreement, formal or informal, between a creditor and a seller. Read it again. A oral or written agreement, formal or informal, between a creditor and a seller. Where you at? Which contemplates or provides for activity, connection with the sale of goods to a consumer. So let me tell y'all what happened. So when y'all went and got that car, for anybody that went and got a car, you know, that's one of the longest processes ever. You're gonna spend all day, all night, breakfast, lunch, and dinner with the people before you drive off, okay? So because go back to me saying that don't forget the dealerships are what? They're credit arrangers. And it clearly tell you here that the contract was between the creditor and the seller. Who is the creditor? Audi Financial, Alley Financial, and who is the seller? The dealership. So where the hell are you at in this contract?
Consumer.
You're the dealer.
You the who?
The dealer.
No, you're not.
The debtor.
You're the debtor. So, but what,
Co-signer.
if the only way to have a contract is a written agreement between the creditor and the seller, where did you come into play at? Y'all read it again. Please read it again. A written agreement between a creditor and a seller. So let's see what they say creditor is. If it's blue, you can look at the definition. A person who in the ordinary course of business needs to purchase money. Finance.
Mute yourself.
Hold on.
Mute yourself, sir.
Oh my God. Oh my goodness. This is
Oh.
cannot. Like you straight using the bathroom. Like, oh my goodness.
I know, right?
Yo, that's
Come on, sis. Hey, sis, mute them all, man.
Mute
everybody.
Yeah, mute everybody. Like, I hear a bunch of background noise.
Oh my goodness.
Jesus.
Please.
And see, this is why it takes
Come
me so,
on.
because I get tired of having
Wow.
to edit things out,
Come
you
on.
know, and at the end of the day, I should not have to hit a mute button for everybody because then, I mean, we have to do extra work. There's too many of you guys in here for that. But unfortunately, between the chat and the, what you call it, whoever used the bathroom, good looking out for you. But like, we didn't want to hear that. Like that was rude as hell. So. So if the only lawful contract is between a seller and a creditor, and the creditor is one in the ordinary course of business, in the ordinary course of business is lending purchase money agreements, that you can't be that. So you're not the creditor, right? We have established that. So now let's go see what they mean by seller. A person who in the ordinary course of business sells or leases goods or services to a consumer. So are you a seller? So if you ain't the creditor and you ain't the seller, and the only way for it to be a lawful contract under 16 CFR 433.1 is if it's an agreement between the creditor and the seller. So this is what happened, okay? Each car dealership has different contracts with the different banks. That's why they can offer you financing through 15 different banks. This is why when you go to one dealership, they done ran your credit 22 million times, right? You get all of those inquiries because that dealership has a contract with all those different banks. And what they do it as a bidding system, okay? On who's going to give them, not you, them, the best rate. Okay, so every car that is on a dealer's lot has already been bought one time. They get an advancement to buy these cars. They sell the car the first time. Guess who they sell it to? The DMV. That's why they want you to get it registered. So the first time they sold the car, they gave it to the DMV. So that's the title right there. Okay, which means once that security is now being transferred, they cannot use that same security to get new financing. So the dealership wanted to get financing from one of their partner banks. And the only other thing that makes a piece of paper come to life is we, the consumers, when we sign contracts. So, for example, you went to get an Audi, it's 70,000. Dealership don't have no more securities because they sold it already. So then they're gonna go in the back. This was take them so long. You see, they never do these calls in front of you, right? So you're gonna go in, they're gonna go in the back and they're gonna say, hey, we need a $70,000 advancement. And then Alley Financial gonna say, well, what do you got for collateral? And they're gonna say, yeah, you know, I got Mr. Jamel out here that just signed a security that's going to be worth this amount of money after it's traded on the market this amount of times. And that is how it does. And because in the contract, you gave them permission, you did, to give them security interest and to transfer. And since applications are considered instruments because they can be transferred to a third party, the loan that you're actually paying off actually belongs to the dealer, right? So the dealer really had 30 days to pay it. And what does a cosigner do? You just cosign. Let me look at y'all just co-sign for the dealership. So what happens when you're a co-signer on somebody's something? If that person don't pay, who do they go after? You. And that's what happened. And you agreed to it. And I'm gonna show you where. Hold on. Let me show y'all something else. Okay. So we understand what all this is. We understand what a consumer credit is, a consumer credit contract. Here we go over that instrument word is any instrument with evidence or embodies a debt arising from a purchase, money, loan, transaction, or a finance sale as defined in the paragraphs. So back to what I said. There was a check that was supposed to be there in exchange for that instrument. You gave them the instrument, you left your check, and then now you paying their debt. So on that contract, we just seen that any holder of this consumer credit contract can assert their rights. Would you like to see it again? 16 CFR 433.2, preservation of consumer claims and defenses, unfair or deceptive acts or practices, and boom, there you go. It says it right here. I'll give y'all a half of a second to look at your contract and then look at that. There it is. So because it says any holder of the consumer credit contract, you guys have a contract in your hand, right? That means that you're a holder of the consumer credit contract, which means you can do your claims and defenses and as the debtor and assert your right against the seller of the goods or services obtained. So who was the seller? The dealership. Who did the dealership send it to? Their trustee. And I'll show y'all that too, how they transferred your money. Okay. So you see that the law is there. So then when you get these companies that say, oh, that don't apply to us. Let's go next again. So this is the exemptions of companies that is exempt from consumer credit contracts. If it was a contract, an open-ended contract before November 1st, 1977. So any other contract written after November 1st, 1977, they are not exempt. So don't let these people keep telling you that it's that way. Okay. I'll even show you guys where it is illegal for a husband and wife. So if I got some husband and wife team on here that co-sign for each other, it's illegal. And then here we go with, because they always want to say it's not a consumer credit contract. It's a retail installment seller, because that's what they put on there. It's still a person who sells goods or services to consumers on a deferred payment basis. Deferred is your first payment ain't due till 30 days. That is considered deferred. And it also said that they are in the jurisdiction of the Federal Trade Commission, which is why it's always good that when you're going after them to make sure you add the Federal Trade Commission in there. Okay. Here we go. So if you have cosign for your spouse, if you go to 16 CFR 444.3, it will tell you that it's illegal. A deceptive act or practice within the meaning of Section 5 of the Act for a lender or retail installment seller directly or indirectly to misrepresent the nature and the extent of the cosigner liability to any person. So a natural person who renders himself or herself liable for the obligation of another person without compensation. The term shall include any person whose signature is requested as a condition of granting the credit to another person, or as a condition for the forbearance or collection of another person's obligation that is in default. Okay, do you guys, let me highlight it for you. Where it says the term shall not include a spouse whose signature is required on a credit obligation to perfect a security, which means a husband and a wife cannot sign for each other. Okay.
What about a parent and a child?
It don't say that. The reason that a husband and a wife cannot co-sign for each other is because at the point that you got married and you got a marriage license, you just created another security and they look at you as one. So what do they say? That when you are together, you guys are become one, which is why they cannot charge you guys the same. You know what I'm saying? So it ties into biblical as well, but if y'all co-sign for each other, that's absolutely illegal. Okay, the entire contract is illegal. So matter of fact, to go back to the contract. So we already see that that's there. You are a holder of the contract, okay? So you do have the right. And here we go, agreement to arbitrate. By signing below, you agree that pursuant to the arbitration provision on page 5 of this contract, you or we may elect to resolve any, that word any means something, by neutral binding arbitration and not by a court action. So, because nobody read their agreements, you immediately signed yourself into arbitration. Now, when I go down to page 5, you'll see, I believe you had 60 days, 30 or 60 days, depending on the contract, to waive arbitration. And so that you can take them to federal court. This is why they do what it is that they do. So you cannot take them in federal court to sue them. They ain't gonna care about arbitrating with you. They're not gonna care about paying you out either, because guess what? It's hidden from the public. So no one can use it as a case law to help them go against these companies. You allowed everything within this contract. Yes, was the contract false and misleading? It absolutely was. But guess what? You signed your name to it and you said that, okay, it's okay. The thing about arbitration and think about any of these contracts, everybody be saying, oh, it was fraud, it was fraud, it was fraud. No, it wasn't. Everything that they're doing, every time they transfer your security to another corporation or however the case may be, you gave them permission to do it. And I'm gonna show you where it's at. You are given a security interest in the vehicle being purchased, right? Go down and pay off early, no penalty, they charge. There's one in here to transfer, and let me find out. There's no cooling off period. They all do that, but under the law, if you know, you do have a cooling off period, but they're only going off state law, because you guys do understand that when you are dealing with contracts, you have a federal law and you have a state law. Like in most states, except a few, and y'all can look this up. In most states, Like North Carolina, I know for a fact, Pennsylvania and Virginia, if I'm not mistaken, it's not lawful to collect on a debt after 3 years. You can use your state law to get the stuff off your credit report or to go back with them. You don't just have to stick to the same federal laws, because you got state and federal that both applies to whatever your situation is. But yeah, it's normally 3 years. It ain't that 7. And they tell you they can stay on your credit report for 7 years, but the right for them to be able to collect in most states is only 3 years. Looking for where they gave her the right to transfer. Like all of these documentation fees and all of that stuff, all of that was supposed to go within the finance charge itself. So, you know how everybody says that the car insurance is included. The car insurance, nephew, when you get a second, that email I sent you earlier with that finance, can you pull that up for me? They always say that it's the car insurance is included. It is not car insurance. It is optional credit life insurance, that was put into this entire finance charge. And if you don't know what credit life insurance is, if you become disabled or you cannot work or you die, unfortunately, the car was paid off. This is why they make you put an ad in the newspaper when your people die, so they can collect the credit insurance that was on that vehicle. So if you lost your job, you became injured, all of that applies up under there. You check that you don't want it, but they absolutely got it on you and it was added into the finance charge. So this is the credit, the insurance that they're talking about, and not car insurance. It's talking about the credit life insurance.
Is that separate from GAAP?
Absolutely, it's separate from GAAP. This is if you become, so it's like a disability insurance, right? So here it is, credit life insurance and credit disability insurance are not required to obtain credit. It's not, but they do it. Your decision to buy or not buy credit life and credit disability insurance will not be a factor in their credit approval process. They get this on you. I'm telling you they do, okay? And you see, they had to choose the insurance. It has to be itemized as an amount finance. Here's a, they will not be about. If you choose this insurance, the cost is shown in item 4A of the itemization of the amount finance. So that would be up here, right? So if it was the amount finance, that means it goes with the finance charge. So y'all know all of these little extra documentary fees and all this little other shit, accessories and installation that you probably didn't even realize they put on there and all of that. That was to cover this. And every dealership has a credit life insurance policy on you. So when you die, or if you become disabled, you are literally supposed to be able to call and get this insurance and never fall back on your car note, ever. So that's what the insurance part. All your maintenance and all of that. And you see, let's see if there's something else on here. The arbitration clause. That's what I want. Nephew, were you able to pull up that other? Oh, this is what I want to. You give us security interest in every one of your contracts. You told them that you gave them security interest, right? But look at the interest that you gave them. The vehicle and all parts or goods put on it. All money or goods received for the vehicle. Proceeds for the vehicle. You told them they can keep all the money or goods received. So every time they transfer and sell your security agreement, your contracts, they get paid for it, right? Y'all hollering that is fraud, but it ain't, because you told them that they can. You told them they can keep all the proceeds. You see, of all insurance, maintenance, service, or other contracts we finance to you. So y'all know how the maintenance fees is included. It just told you right here. But it told you that you're gonna pay it, and all the money that they receive for the insurance, which is the credit life insurance, the maintenance, which every car, it comes with the maintenance and the service, you told them that they can keep it. Then you told them all proceeds from insurance, maintenance, or service, or other contracts we finance to you. This includes any refunds or premium or charges from the contract. Y'all told me to keep. Y'all told me to keep.
Excuse me, Tamika, the Zoom had stopped and we couldn't hear anything you just said.
What part didn't y'all hear? Are you?
You
No,
had-
I heard
I did
everything.
hear.
I
I
heard
heard
everything.
I heard everything.
Really?
heard
It cut
everything.
out for me.
Okay,
I
I'm
heard
happy that it. I would have
I heard
repeated it
everything.
but let me tell y'all something. The bad energy, the devil, whoever on this live, or however the case may be, is not gonna stop this live from going down. Because if y'all, for y'all that's new in here, y'all didn't have time to go look. Every contract that you've ever signed, from your credit cards to everything, is an arbitration clause in there. Okay. The reason I say is a do not pay, do not collect, because as soon as you put it in arbitration, they can't repo, they can't cut you off, and they cannot take any money from you. And then when you do arbitration, unlike federal court, the company has to pay for it. So only thing you're doing is putting the claim in, but you got to make sure that you put it in right. So I don't know whoever that was that you said that they don't want to give you the bill of sale. No, they do not. It's a purchase order. Ask for the purchase order. Okay. If they do not want to give you the purchase order, this is one good thing about arbitration. They got to come up with all the documents, right? And they're going to try to play you and tell you, Butterfly, where you at? Raise your hand for me. They're going to try to tell you to send them a copy of the contract that you have. Don't do it. Please don't do it. Don't do it. Don't do it. Because they're trying to see what it is that you got. Hold on. Sabrina, she can.
Yeah, I'm here.
Okay. Can you tell them just a little bit about, because she can say it now too. It's like fully done. How they've been trying to get that contract from you.
So they still emailing me too. But they basically was trying to have a conversation with me like offline, and I was going to have a conversation, but we ended up rescheduling the conversation. And then I got an email for arbitration, and it was like, oh, they extended the payment to January 10th, which was today. So I started realizing they asked me for the contract. They was asking me for like the payment transactions and everything. And I started realizing like, wait a minute, why they asking me for the contract? And then as soon as I asked the attorney, he's like, oh, well, we can't get it from the company and like all this other stuff. And I asked him, well, why are we having this conversation? He was like, I want to understand why you put the claim in. I'm like, arbitration already gave you guys the reason why I put the claim in. So they basically was just trying to give me like the runaround before it was no arbitrator even in the middle of that conversation.
See, and then the thing is, the reason that they want the contract that she has is because they don't get that same contract, right? When you guys call your finance company and you tell them to send you the retail installment agreement, you know who they call? They call the dealership and have the dealership send it over to them. That's why they tell them to keep it for 7 years. The only thing they got on record is a purchase order that said that that was a credit for whatever the full amount was. Good thing about arbitration, if you don't give up yours, and I'm going to say it again, do not give them people that contract. Do not put the contract in the arbitration papers. Don't even say too much in the arbitration papers. You don't want these people to know which way you're coming. That fan don't need to know what the right hand doing. You file an arbitration, the company has to pay for the arbitration in order for it to take place, but they have to give a discovery. They even got to send their their resume in, they have to put their job, all of this and everything that's in your file, they have to send to arbitration. And if you turn around and send them your contract, what do you think they're going to send? They're going to send your contract, because arbitration goes by contract law. And the contract I just showed you, you told them they can keep the money. You told them they can keep the proceeds. You told them that you were going to give security interest. You told them, so if you give them that, arbitration going to say you got to do it because contract law is a law. You signed it and you said you understood it. So going into this arbitration is nothing to play with at all. April.
Hi, what if we don't have, like, I have one for Navy Federal and they don't have that notice in mind?
Do you got your full contract?
This is the one on my account that I printed off.
No, it's not gonna be the same contract. You need to call them and tell them to send you your contract, because that's not the same
contract.
Okay. You have to tell them. But even if do you have an arbitration clause in there?
No, they told me that they don't do arbitration.
Oh, no, they don't, because credit unions are nonprofit organizations, and Navy Federal is actually doing business under the security exchange as Navy Federal Financial LLC, if I'm not mistaken. So Navy Federal, the credit union, is a subsidiary company for their main company, which is the company that can actually transfer the notes. And if I'm not mistaken, is Navy Federal Financial LLC. So if you look it up that way under the security exchange, then you'll see their security agreement, and you'll also see that Navy Federal Credit Union is working as a subsidiary company under the parent company, okay? And that's the way you have to go at them. Chocolate?
Yeah, okay, so my question is,
Oh, I can barely hear you.
can you hear me?
Barely, we can barely.
You're coming very low.
If anybody that can hear me, if you can repeat it for her, basically my question is, there are a few places on my contract that have like a forged signature, and it's not the computerized signature, it's actually like a forged signature. And in the part for the arbitration, that part is a forged signature there. So I'm wondering, like, do I even have to go to arbitration? Being that
You go still, yes, because the contract said it. Now, as far as the signature goes, that will be something that you will have to talk about via the arbitration. But yeah, you still, it's there. So you still got to do arbitration.
Okay. Thank you.
You're welcome. Eli.
Hi, Miss Tamika. Can you hear me?
Hi, I can hear you well.
Okay. I have a lease agreement with Chevy, but it did charge me with the down payment. It did charge me for the first month, even though it said I wasn't going to have a payment for 30 days.
All right, so it's still, even with it being a lease, leases are the same thing. It still falls under a retail installment agreement, even as a lease. The only difference is at the end, you're giving a car back when technically you actually bought it. That's all. It still is the same way.
Okay.
Okay. You're welcome. So. So as y'all see, is the arbitration is there, the law is there. So now the thing is, arbitration has its own laws. They have rules. And we will go over those. Exactly what arbitration is, why they use it. Ultimately, they use it to keep it out of federal court. Because if it goes into federal court, let's say with all these people on this call, let's say everybody went after their car company and you did it at the federal court level. That's going to trigger the FTC, which is going to trigger the SEC, and companies are going to get shut down and closed down. They also don't want it on the record that you can go and sue these people and get your money. Now, the law did change this year. And the new law says that arbitration agreements are illegal and they can no longer add them to your contract. But if you're already in an existing contract, you have to follow the arbitration rules unless they sent you a new updated terms and conditions. And every bank has sent everybody, they had to, before 2023 came in, send everybody a new updated terms and conditions. I guarantee you, you ain't opened the email, you ain't thought nothing about it, but you might want to go open up your new bank's terms and conditions because they all changed, including they can no longer have arbitrations in any agreements any longer. Okay, but it doesn't stop anything if you already are in a arbitration agreement on your contract already. If it's already on the contract, you still have to go arbitration. So we'll talk about the different levels of arbitration. So you got arbitrary and non-arbitrary. Everybody contract has an arbitration, so it will be arbitrary dispute. So we'll learn the duties of the arbitrator, the benefits and the drawbacks, and the kinds of arbitration. Can y'all see my PowerPoint? Did I got it? Well, my little paper, I got it.
Yes.
Okay,
Yes.
perfect.
Yes.
Perfect. See, look, I did a little extra for y'all today. Hey, no.
Thank you.
So, you're welcome. So I actually, y'all are seeing a preview of what's this going to look like in your back office. So when you guys get this recording, it's actually coming in your back office. So pay attention to the email that comes. But this is kind of like, because it'll help you to have the video and then something physical with the exact point that you need. So this is some of what's in your back office, okay? So,
Thank you.
You're welcome. You're welcome. You're welcome. It's 2023. We stepping on next, baby. We got to get it. Because
Since when you ain't doing the most.
Like,
Yes, yes.
Baby, we breaking neck too.
Breaking them because I need everybody to win. Everybody.
Man.
Excuse me.
All right.
Is
So we all know. Go ahead.
Is everybody have access to the back office, or it's
You
just a
will.
different group?
It's y'all group. Y'all the members. Only the members do. So like, if I put this class in my store, those people that just get it, they won't have the back office. You only get the back office if you're a member. And this time, for real, I'm not opening the membership back up. Like, y'all, I just got so many requests and I want everybody to win. So I opened it back up, but it will not be open any longer. But this information and things that you guys are seeing, if you're a member, and as long as you stay a member, you'll have access to the back office, okay? And it'll come in the email when I send the recording. It'll come with inside of the email how you are to be able to get into your back office, okay? Because it's only for members. So we all know that arbitration is a process in which a dispute is submitted to be impartial outsider. So that's where the arbitrary person come in. They ain't on your side, they ain't on their side. It's a neutral person, okay? Know that you're gonna be going up against these people attorneys, point blank period. They got an attorney and you're going up against them, okay? Who will make decisions, and which is usually binding. So now they use the word usually, because it is usually. Normally, if you go through an arbitration and you lose, it's over. But see, we got that ace in the hole, y'all. And the ace in the hole is what? Title 12 says that anything dealing with a security is an automatic federal case. So y'all know that means y'all lease too, right? That's how you get an eviction moved from state court to federal court. Okay, because your lease is a security. So just for FYI for you. I know how to put a few pictures up there, y'all. So
in these agreements, in these agreements, these contracts, is it true that we can go through there and line out things that we don't agree to and initial them or something like that?
Yeah, you have 30 days to do that. That's why they give you 30 days to pay. And because when you think about it, you only have a contract. How many people do it take to make a successful contract?
2.
Anybody? 2. How many signatures is on there?
1.
Fools. yours. So now the law
Mine.
says, right? The law says they have 30 days to give you a completed contract. And the only signature that is the lawful signature to complete it is the trustee. So yeah, you had 30 to change the contract within itself because it's a one-party contract. So the basic arbitrator enforced his own point of view on the contending parties, and the opinions of the participants are not giving any predominance. Okay, so they don't care what side y'all on, they only going by the right side. Okay. Arbitration, even though it's not a traditional judicial process, it still is a judicial process. Okay. The award of the arbitrator rests on what? Equity and justice. There is no scope for compromise. This is why you got to be rooted and grounded and have that foundation, because now 16 CFR 433.1, 15 USC 1692, 1635, all of them now will come into play, but you better know them. Okay, there's no room for compromise. It ain't gonna be like, oh, well, they signed it. No, because the contract was far from the beginning, from the inception of it, because it started with the dealer. Okay, now, whether you realize it or not, the contract said arbitration for who? The seller. So on your arbitration suits, not only do you put the finance company, you're going to also put the dealer, because dealer fraud. Okay, and that's how you collect the check. I seen a news thing, or I was somewhere, and a girl actually got her purchase agreement, and 1 cent was off on the number compared to the application, the contract that she had and the contract that the bank had. The dealer had to pay her $50,000 for being 1 penny wrong on that document. Okay, so when you do your arbitration, you're going to add not just the finance company, you're going to also add the dealer so that you can get them for dealer fraud and, you know, collect you a bag real quick. Here's how the arbitration process works. The case is filed, is normally filed by you. Any one of the parties can file it. So you will file the case. Then they will select who your arbitrator is. You will have a preliminary hearing and a scheduling order. So this is when y'all heard Butterfly saying that they're trying to get an off the record conversation with her. They are. They're trying to do it without the arbitrary before this preliminary hearing, because they really trying to see what she know. But they don't know they're gonna get me tomorrow. Matter of fact, and it's tomorrow. I think it's tomorrow. So then the discovery process. Okay, so y'all remember when I said they're gonna keep asking you for your note, because they got a certain amount of time that they got to come up with all of the paperwork. So how are you an attorney for Audie, but you say that Audie ain't got no paperwork? They gave you the paperwork, but you know that shit ain't right. You know what I'm saying? Like, you know that it's going to prove the fraud. So you want to wait. You don't want to give up nothing. You want to wait until the corporation or the finance company, whoever, sends all the paperwork to the arbitrary, because guess who the arbitration person sends all of the paperwork to? You. Now you have your purchase order. Now you got your more ace up in the hole, because, and they can't say the paperwork ain't right because they got it from the finance company's attorney. Okay. So just know in the process of doing your stuff for arbitration, don't give up too much information, and don't give up not one contract. Okay. That's like you going to murder somebody and you tell the police where the knife at. Like, who does that? You better act like you're on first 48 and shut up. Right. You know? So that's the discovery process. You will get it in the email. Like I said, they have to give them their resume, because remember, this arbitrary person is impartial, right? So they don't know nothing about neither one of y'all. So they got to give up the resume. They got to give up a whole bunch of stuff, okay? Including them contracts, all of them. And they got to prove that the payment history, but you can't pay a debt with a debt. So what they prove, okay? I'll catch you. So then you're going to have the hearing.
Tamika.
Right? Yes.
I just wanted to know, you said don't give your contract to them. Who is them? I mean, can you give it to the arbitrator?
Yes, you're going, you know when you're gonna give it to the arbitrator? Because y'all got a timeline. You're gonna give it to the arbitrator after they done sent their discovery, and then you'll send it. Do not send it before. And in this case, in her case, they're not even, the arbitrary person haven't even asked for it. The attorneys is begging her to send that paperwork because they know that her contract ain't gonna match the contract that Audie just gave them. And they already know that we going after. We just left it simple with securities fraud. We ain't got no more in detail. They would never know how much we know until we get at that bargaining table. And then that's when, because I'm on her call with her, that's when I'm gonna tell them everything that I know so I can get her what it is that she gotta get and we can leave it as private. And then unfortunately, she'll just put the thumbs up when she wins because she can't tell y'all. Like I won't even be able to tell you, but we can tell you thumbs up. So if y'all hear us say thumbs up, just know baby girl got the period. So then you're gonna do the arbitration hearing. Then you're gonna do the post arbitrary briefs, and then you're gonna do a final arbitration award. Okay. So somewhere in between these two, the arbitration is going to, the arbitrator is going to say, is there any way that y'all can work this out on your own? Okay. And if you do your stuff right in between this part right here, okay, and you'll have that foundation that you need to be able to make sure that this part is correct, then you ain't gonna have no problem because they're gonna want to throw it out. They're gonna want to try to give you what it is that you want. And at that point, I will make sure that get what you want. Do it right and get what you want. Okay. So that's how the arbitration goes. So these are the type of disputes that you can bring for arbitration. Hey, wait, go back. Okay. So these are the different disputes that you can bring for arbitration. Anything dealing with property. So we know the cars, houses, blah, 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 that is all considered property. Your insurance, so like your insurance companies, the car insurance company, the life insurance companies, they're all consumer credit contracts. So it all runs, yes, you can do arbitration for them. Contracts, including employment contracts, business partnership and disputes, family disputes, except divorce matters. And we all know why you can't do the divorce matters, because you are now as one and they're securitizing your marriage license. Okay. Commercial recoveries and construction. Things that you cannot take to arbitration are matters of criminal nature. Okay. Just pay the taxes on it and, give them your birth certificate because that's all they want. That's how you give her that crime stuff. Okay. Disputes relating to matrimonial relations. Of course, that's husband and wife again. Anything dealing with a will, anything relating to trust for public purposes of charitable or religious natures, insolvency matters relating to the guardianship of a minor or a lunatic, and that is actually in there, and any execution proceedings. Okay. So now the duty of the arbitrator is to administer an oath to the parties and witnesses appearing. So let me tell y'all something. Yes, they gotta take an oath to tell the truth and the whole truth and nothing but the truth. That's why they want your contract. Okay, don't give up that contract till you get that email with all that good stuff on there. Okay, y'all gonna hear me keep saying y'all, because I need y'all to know the importance of not giving up left hand, right hand. You hit them with a pow. You know what I'm saying? Like, you don't want these people, they're attorneys, right? These people are attorneys. So if you tell them what you're going to do beforehand, you don't think that they're going to be prepared for that. But see, they can't be prepared when they don't understand. Like with her first initial call, right? They didn't know that I was going to be on there, because I know under the arbitration law, it says that you can have a witness. And it also said that you can have a consultant, which is why Path to Freedom runs up under Henry Ross and Consulting for you guys who may need me for arbitration, or you may need Caleb for arbitration. We can legally do it because I am a consulting firm. Okay, and that is a part of the arbitration laws. Unlike if you're in a court case, they're like, she's not a lawyer and I can't do anything but talk to you through an earpiece to make sure that you win. But in this case, you can sign a piece of paper and you can just sit on the call and smile. And then I can finish the rest. And it literally can go that way. Okay. So they're going to administer an oath to the both of you guys and your witness. They're going to act judicial and impartial, though. It ain't going to be like them judges, okay? It is for them to put the necessary interrogatory to any party to the dispute, okay? to determine by and to whom the cost of the reference and the award shall be paid. The award interest and the fixed amount of mo and the time that you'll get paid. Okay, so when you're going into these arbitrations, make sure you know what you want. But let me tell y'all something. Okay, because look, I know how people can be. Don't be going in and talking about I want $100 million trillion. Don't do that. Okay, please don't do that. don't try to. You don't have a
$1 billion.
come up. But please don't be going there and somebody need $100 trillion. Okay, but what you can say, right? You can tell them that the value of the contract is belong to you. So if you got a car that was 72,000, say I need the 72,000. If you got a car and they ain't repossessed it, you're gonna say, and I need my title free and clear, and I need my manufacturer's title, my MCO title, which is the head title. So now you just took away from the state. Depending on how much dirt you do have on them, like in the case where girl, they did for her signature, you can add in there something like, I get to come get a car once a year. You can add whatever when you got them by the balls. Nah, just don't be like, I need $100 trillion. If you're taking an arbitration and your car was already repo, I would make sure I ask for me a car free and clear, so that you want to take the money you just got from them to go buy you another car. You know what I'm saying? But do everything in reason. Okay, whoever's snoring, can you just hit the thing? Please hit it. Caleb, can you just mute everybody for me? Because that's the part that I do not want to have to edit out.
Hi, I'm sorry to interrupt. I just had a question for you really quick. I wanted to get off my cell phone. I want to know if I could log off but log back into my computer. Would you let me back into the room?
I'm not on that page to let you back in, and it's automatically closed, so it's not going to let you back in.
Okay, then I'll just stay on my phone. Thank you.
You're welcome. Yeah, I lock it at a certain time because people like to be late, so it gets closed down. So this is how it goes. Here's just a little diagram. You got the arbitrator. You got the issues, decisions, grants, and rewards. You have the determination of facts. It applies rules and laws. So guess what you need to know? You need to know the law. And if you don't know nothing else, you better remember 16 CFR 433.1, because if they ask you what right do you have to bring this for arbitration, it's on your contract. Any holder of this consumer credit contract, any holder. If you're holding that contract, you are also a holder in due course, okay? And you're going to make sure that you know the laws. We know the truth in lending laws and the other ones in part 2. We're going to go through the different laws that you want to make sure that you put down so that you can win your arbitration hands down. Okay, if you go at these people right, they're gonna want to settle with you quick. Sign the NDA and shut the hell up. Okay, they're gonna be watching your social media pages. I'm telling you now. Like, I'm not playing. They're gonna start watching your social media pages. They're gonna see if you're gonna get the bragging, like, yeah, I just beat Allie. And then Allie, you're gonna wake up and whatever money you got gonna be out your account. And they're gonna be like, you violated the non-disclosure agreement. Okay. So that's a diagram of you do that. How that works. So here are the advantages of arbitration. Your choice of decision maker with expertise. Now, the wonderful thing about doing arbitration, you get to pick the arbitrator. You can say, yes, you want them, or no, you don't want them. If you need an expert witness, like girl, who your thing is, your signature is forged. Yeah, you make sure you get a handwriting expert, and guess who got to pay for it? The corporation does. With arbitration, you're not paying for anything, right? So use it to your advantage. So you can get an expert to come in and show that that is a difference in signature. Arbitrations go by extremely quick. It is a lower cost, but as I said, you don't have to pay that cost. It's flexible. Here we go. You hear that? See that? Confidentiality. It's within the arbitration law that, as I said, you have to sign an NDA and you cannot speak about it. That's how you don't know these companies are having to pay out. And it's less formal than a court, and it's a preservation of business relationship. The disadvantages, and this is why when you go after them, you got to go out there with everything you got. But y'all got me, so y'all gonna be all right. You know what I'm saying? You got me and Caleb, we're gonna have y'all together. But anyway, you got limited recourse, period. Y'all see That limited recourse. I pulled this straight from the law now. I'll show y'all the law. Limited, which means if you fuck up, you hit. Okay. Now, y'all do got y'all ace in the hole, so throw it in the back of your head. Anytime dealing with a security is a federal case only. But if you've already lost arbitration, you're gonna have to make sure that your federal documents is A1 so they won't kick it out. And I'm gonna tell you just like this, if you can't beat them in arbitration, you're not beating them in federal court. Hear me again. If you lose arbitration, you ain't winning in federal court, so you might as well just find somebody else to go mess with after that. Like they say, get somebody else to do it. Because yeah, get somebody else to do it. Because if you lose in arbitration, you're here. I wouldn't even advise you to try to take it to federal court because you're gonna lose. It's an uneven playing field. So what it means by that, remember I told you guys that you are literally on there with attorneys. Butterfly, I'll tell you guys, they got about what, 4 or 5 different attorneys tagged on there. On the very first call, it was 2 male attorneys, and they thought that they was about to bully her. But because I know with arbitrary rules that as a consultant, she can have a witness, either a witness or a consultant on the phone with her. And the way that they did the call, it was something how you had to say your name first for them to let you in. So you're on their server, so you can't save it. And it wasn't no Zoom. It was like some Microsoft something. And then I had to say the name of the company. And as soon as I said it, oh, they want to reschedule because they thought she was going to be on the line by herself. Okay. So that's the uneven playing field. The lack of transparency. Don't forget it's sealed, it's confidential. Of course, the parties pay for the arbitrator and it will be on them to pay. You got limited rights of appeal. Right again. You got limited rights of appeal, which means if you lose, as I just said, trying to take it into federal court it's not going to be easy for you. Okay. And the lack of formal discovery. So now even though they do have to give discovery, right? There's no formal audit done. So they can send them anything, which is hint while they're trying to get her contract from her. So they can send them that same thing because they can't go to arbitration with no contract, right? That's just not going to happen. And I can guarantee you the dealership don't have it no more, so they can't even get it from there. They don't know what they have shit's creep. So they can't just come, because if they come with no contract, she automatically won because they have nothing to compare it to. And if they come with a fraud contract and the numbers don't match, she won. And since they don't know what numbers is on the fraud contract, them numbers ain't gonna match. Okay. So a lack of formal discovery. Like I even put a picture up there. I was doing a little something. So these
Can
are the
I just say I love how you
types
laughing?
Oh, thank you. Life is good, y'all. God is good. Like, because we about to look, these people ain't gonna know what to do. They head about to turn. Like, I'm telling you, all your contracts got an arbitration clause in it. Your rent one do too. You just got to go on their website if you got a corporate landlord. So these are the 2 types of arbitrations. You got a voluntary arbitration and a compulsory arbitration. Okay. So now, due to the fact that you voluntarily signed that piece of paper and you did not waive your arbitration, you're going to always fall up under voluntary arbitration. Okay. So it implies that 2 contending parties unable to compose their differences by themselves agree to submit the conflict dispute to an impartial authority. So this basically means, y'all know how y'all been trying to send affidavits and remittance and whatever y'all trying to do to get rid of your car, right? And y'all have not been able to, they ain't doing what you want. So that's different. So that gives you the right to bring in your arbitration, okay? So now, essentials of the voluntary arbitration. The voluntary submission of dispute to an arbitrator, so either one of you guys can voluntarily do this. The subsequent attendance of witnesses and investigations. Okay, you need that, witnesses. So all that, they want to have you on the phone by yourself? No, that it don't work like that. The enforcement of an award may not be necessary and binding. Voluntary arbitration may be specially needed for disputes arising against agreements and contracts, which is what we're going through. Then you got compulsory arbitration is one where the parties are required to accept arbitration without any willingness on their part. So that normally could have fell up under you, but due to the fact that you signed the contract and you did not within the waive period, with the 60 days of signing the arbitrary agreement, that you decided not to opt out of it, you're stuck with it. Okay, but moving forward, first of all, the arbitration agreement is not supposed to be in there. But if it is, don't try to go back and forth with these people like, well, the law said they're not gonna change their contract for you. Okay, they're not. So what you do is you sign it, but you have a 60-day time period from the time that you sign it to send them an opt-out letter, and you send it register mail saying, hey, I'm now opting out of your arbitration. Then at that point, you can take it straight to federal court. Okay, and we don't really have to go over the compulsory arbitration because y'all doing voluntary, but these are the other types of arbitration: institutional, statutory, domestic or international, and foreign arbitration. And these are the difference of all of those. If you are dealing with your business, if anyone has any businesses and you are challenging your contracts, then you would do an ad hoc arbitration because that is considered a commercial transaction. So for my business owners, yes, you do have recourse because there ain't no money either way it goes, period. So the institutional arbitration as well is through commercial transactions, okay? So, oh, I see a whole
Tamika.
bunch of hands. Let me see.
Oh, sorry.
Yes. No, you're good.
Hey, real quick. First of all, this presentation is excellent. Thank you so much for the PowerPoint. I think you did an amazing job. So thank you for that.
You're welcome.
I have a question though, because for me, excuse my ignorance, yeah, but I don't know if I have my contract. So I need to call them and ask for the things that you meant, that you told us to ask for, like the bill of sale or the purchase order.
Wait, hold on. Let me tell you something. If you don't have the first contract, don't call them talk about no bill of sale or nothing, because then they're not gonna want to send you nothing. So you know how you gotta play blind hair, blue eye. Oh, I'm sorry. I don't mean that by nobody, but you know how sometimes you gotta play crazy? You know what I'm saying? So play crazy and be like, hey, I just moved and I'm getting my papers together and I can't find my contract. Can you send it to me? That's how you get it. And then through the arbitration process, you make them tell on their self. Don't give them that paper. But like I said, the next class, y'all know exactly how to write your arbitrary document to a point where it's sufficient enough to get them to say, oh shit, but not too much where they're gonna be like, we know what the left hand, the right hand, the top hand, the bottom is doing, right? Because you're gonna save that for the actual physical hearing. And you make them give their paperwork. So just call them, the finance company, and say, hey, I lost my contract. Can you send it to me? Be all nice, and that's it. Get that contract and then go from there, okay?
Period. All right, thank you.
Period. You're welcome, Jamel.
What's happening, sis? Oh, okay. I remember earlier, a little bit
Hey, what's
earlier,
up, bro?
you said, man, you know what it is. Just hey, you showing out. I've been waiting on this one for a minute. Yeah, I've been having my contract and I've been reading. Look, I've been reading the crap out of it. But like you said, with the like a credit union, like you said, them being a nonprofit. Like with my car up under that one I told you about, we talked about. So how would I find the parent?
So we're gonna have to get the looking, because with them being a nonprofit organization, in your state, well, whatever state that they are registered as nonprofit organization, because it's nonprofit, it is all public information. So if you get their nonprofit filing, it's gonna tell you who their parent company is. And the parent company is going to be a financial company that is acting as a security transfer agent, and they are going to be within the security exchange. Okay, and that's how you go there. I am in the process. I ain't want to say much, but I am in the process, because time is running out. I am in the process of creating something that'll make it easy for y'all to just go to a page and say, oh, there it is. You know what I'm saying? So yeah. But just get their nonprofit information and then look for the parent company there.
You know, I appreciate you, sis. You know, I love you, man. You don't even know I've been working like hell. I got a lot of stuff coming. I've been getting it in. I've been quiet because it's important for me to take my time, and I just like to eat my breakfast, lunch, and dinner every day.
That's a good thing. And as long as you keep doing that, you're gonna be a beast when it's all over with it. And that's
Oh, you bet.
That's the thing,
I,
you
I
know,
ain't, I
I
ain't gonna have
want
you
you
in vain.
guys to read different. Brandon? Brandon?
How you doing? I just had a quick question. So if we didn't have a car contract yet, but we were actually fixing our credit to necessarily get one, you said that the arbitration process had started off or stopped with the contracts already. So if I was to get a brand new car this year, there wouldn't be no arbitration clause in that?
It's not, it's legally it's not supposed to, but you know, these people do what they want. And you ain't supposed to know that ain't the arbitration clause is there. It's not supposed to be there. So my advice to you is don't go in there trying to be Superman, sign a contract. Okay, just sign it. But that contract is going to also tell you, and up under arbitration law, you got 60 days to opt out. So get the possession of the vehicle first, okay? Get the vehicle, let them commit the fraud, send them that opt-out letter within 60 days. And then at that point, you can take them straight to federal court for securities fraud, but you better know what you're doing because you know attorney is going to take your case, I'm telling you. And unfortunately, unlike arbitration, I can't go to, well, I can go to federal court with you through an earpiece where I can hear and give you the answer, but you know, we crossed that road and we ever got to be there, okay?
Yeah, so would it be better just to leave it like not opt out, or would it just be better just to opt out anyways and just try it with federal court?
It's up to you. It depends on how strong you feel that you are. If you don't think that federal court will be where you can handle this, then don't opt out of the arbitration. But now, can you use that fact of the law against them to show that the contract is fraud? Absolutely. Because then at the arbitrary hearing, you can bring up the law that was passed on March the 3rd of 2022, and it took effect on November the 1st of 2022, that all arbitrary agreements are supposed to be gone. So that'll give you another ace in the hole to get some more money and to win them through arbitration. Okay.
Understood. Thank you.
You're more than welcome.
Excuse me. I'm sorry. So the main process you want to do is you want to opt out of the arbitration, right? That's if you want to go into the civil, right? Am I getting that right? I'm a little slow.
That's if you want to go to federal court.
Okay, that's the only thing you opting out of, right? Out of 60 days, right?
You got 60 days, but I suggest that you don't opt out of it. Like, don't opt out of it unless you have the foundation to battle these people in federal court. Just do the arbitration. But I got to tell you what's right. You do have 60 days to get out of it. But I'm not going to also set you up for failure. And if you can't run this stuff down, like you bleed this, and I ain't talking about reading from a sheet of paper to go after these people, because even with doing the federal paperwork, if that paperwork is not even turned in right, the federal court has the right to say they're not going to take your case, which means you're going to have to prove that it was a security. You're going to have to prove what it is that they have been trading your security. But wait a minute, hold up. Don't forget you told them that they can keep the proceeds. So unless you get a forensic financial audit done that's cost a minimum of $5,000 to get ran, keep the arbitration agreement, do it through arbitration. And if the arbitration agreement is there, just win that way. Okay.
Thank you.
You're welcome. Lynn,
I got a question.
Pick your battles in this. Lynn.
Hey, Tamika, how are you?
Hi, I'm great, and you?
I'm good. So I have an agreement before me, and it's through the credit union. And I've co-signed, they had me co-sign with my husband on this agreement, on this contract. Do you think it's better for me to, approach it from the fraudulent side of them having me sign and it's illegal, or should I do the arbitration?
But okay, so this is what y'all not understanding, right? Let me tell y'all something. Your contract says that in order for you to bring claims and defenses, it has to go through arbitration. Y'all trying to skip that. The contract says, right? But guess what though? This the kicker in arbitration. Arbitration work both ways, baby. So they wasn't even supposed to repo you unless you went to arbitration. Arbitration just don't work on that way. The only way they can do claims and defenses, even though you gave up security interest, blah, 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 and all that good stuff, The arbitration law said there's an arbitration agreement there that both parties have agreed upon, and clearly both parties agree because it's on the contract, right? They're not even lawfully supposed to repossess you without going through arbitration first. So what you do is you build your fraud case up, right? And you present it in arbitration, because don't forget, arbitration is about equity and law. Now you do have the law on your side. Just know all of them. Don't just be like, oh, this law says the cosigner thing, and that's it. You're going to do everything from the dealer saying that he the seller when you're really a credit arranger, when the credit contract was really not in between you and the finance company. It was between the seller and the creditor, and you was held as collateral, down to the fact that it was supposed to be a money purchase loan under 16 CFR 433.1, but I never got any proceeds from it. When you go after them, you don't just pick one thing. You give a list of every piece of fraud that you know that they've done, even to how they transferred the contract and how the senior notes and how they filed it to 99C or the A, depending on how long it's been. Like, you add all of that to your arbitration agreement, because you know what's going to happen? I told you there's a point in arbitration that the arbitrary is going to say, can you two work it out personally? I'm telling you for a fact, you hit them with this in arbitration, they're going to give you what you want. But don't be in there talking about 15 USC 1692. That shit not gonna work. Okay, that's not gonna work. I got it.
Okay, thank you.
You're welcome. Allie.
Hi. We have a situation where I had a contract for a car, and my husband was a co-signer. So now I'm looking at my contract as being a total fraud just based on that.
Correct.
And I was wondering if I should just go ahead and do the arbitration on. I did do a process to recoup, the payment on the car, but I don't know if I would be messing up anything if we try to go through arbitration.
This is what I want y'all to understand. The only way that you can put claims and defenses on them is through arbitration. Y'all contract said, like, it's, and this is why I do my classes the way I do it, because there's so much misinformation out there. They're like, oh, just send an affidavit, blah, blah, blah. You know why they're ignoring your affidavits? Because your contract said to do it through arbitration. It's telling you to do it through arbitration. Okay.
And actually, you'll see a lot of times in response to people just sending affidavits, they will say, well, according to your contract, you need to put us in arbitration if you have any issues, and you're bound by your arbitration clause. And so people will be like, oh, they're just denying my affidavits. But really, you have to look at what you agreed to.
You have to see, it's not about trying to beat them. You're going to beat them, but you have to do it by the rules, because guess what? So like he just said, a person sent the affidavit, they ain't got to answer, but you know what they do answer? Put in that arbitration. I think it took not even a week from the time that Butterfly put in that arbitration request that they were sending her paperwork. And then guess what else too? See, I'm trying to save y'all some money, right? At the moment you put it in arbitration, they cannot repo, they cannot collect. This is how you get your bill and do not collect, do not pay status. No negative action will come against you at the point you put it in arbitration. I'm trying to save y'all some money at the beginning of the year, okay? Trying to save y'all some money. And you make sure you work the arbitration out right. You say what? No, they do not report negatively. While you're going through the arbitration process, they will still update your credit report, paid as agreed. Okay.
Excuse me. Now, this is a whole complete different process from a 1099, right?
Yes.
Because 1099 is just, we're going to discharge your whole deal.
1090, but even with the 1099, they depending on the company, some will say, hey, I'm gonna do it. And you get a lot of these companies that are stuck in their ways and they do not want to do the right thing. But you know what you can do during arbitration? You can request for the documentary evidence that they filed that 1099A as soon as you got that car. They had to file it by March the 31st of the next year, which meaning if you bought a car in 22, these companies got until March the 31st of 2023 to get that 1099 1099 in. So that can be part of the documentary evidence of which it is that you asked for. You can also do a freedom of information request of your entire file from the IRS location in Atlanta. Okay, I'm not going to give you the address, but I will tell you that it's in the Atlanta area and it's the only one. You do a FOIA request for all 1099s that have ever been filed in your name. 1099As are for debts that you are currently paying. 1099Cs are for debts that are at least 3 years of age with 1 year of non-collect activity. But just do a FOIA request and then you'll have it. But you can ask for that and you can bring that up during the physical arbitration. I'm trying to tell you, arbitration is the way. Like,
FOIA?
FOIA is freedom of information request.
That was Social Security?
Miss Tamika, can I just say
What-
this? You know, I'm your girl.
We're not talking about Social Security.
There are people with their hands up that have been waiting, but other people jumping in and asking questions. And you know, I ride with you all the way, but it has
Who
to
is
be
this?
there. Boss lady.
Good job.
I'm
Good job,
saying,
boss
like,
lady. Y'all
there
heard
are
her?
new people in here.
Good
So the
job.
way we run this class is when people's hands are up, that's who she chooses. If your hand isn't up and she hasn't said your name, don't jump in and ask a question. There's over how many people on this live? 311. Let's hold this
My
class in
apologies,
equity
I
and
agree.
fairness.
My
Okay,
apologies,
so
I agree. This is my third class just to get through. So
everybody mute until you are called. That's how we'll get through this class and everybody will get what they need. Thank you, Ms. Tamika.
No, thank you. I appreciate you. Absolutely. You know I do. So she told you how the class run and it does run that way and I appreciate it. Thank you. Because what ended up happening is, y'all see, I didn't say anything. I let it go on so long and then I just be like, okay, I'm done for today. Because not too many people present you guys with a class and then try to attempt to answer as many questions as I do. And they normally just leave you with the stuff and say, okay, keep it to moving. And I don't do that. But in the same token, I would expect the respect that needs to be given. So she was absolutely right, which is why I did not stop her. And that's that. And of course, I'm trying to call on people that I don't call on or have not called on because it wouldn't be fair to keep calling always on the same people. Yama, Yamaya, girl, Ms. Roberts. I don't know how to pronounce it right, but Ms. Roberts.
Hey, how you doing?
I'm great.
It's Yamia, by the way. But thank you for calling
Yamia,
on.
okay.
Yes, ma'am. Yeah, so I was wanting to know if I recently just got into a car accident and I totaled my car, but I was still making payments on it. How would I go about with that? Like, could I still file for arbitration? Because I know like they would probably put that on my credit, right?
Correct. Yes, even though the car is totaled, you can still file for arbitration. The thing is, the day that you signed the contract and you gave up the security, the car was paid for. So most definitely, you can still do arbitration. You got technically the entire length of the contract, but the best to do it within the first 3 years. But yeah, you can still file arbitration.
And one more thing. So I don't have the original contract, but I did call and ask them if they had a copy of it, and they told me that the lien holder had like my contract or something like that.
Oh, who did you call, the dealership?
Yes, I called the dealership.
No, if you already got in the vehicle, you will be calling the finance company. The dealership sold your contract and they burned the original.
Okay, so I called the.
No, they didn't have to burn it because everything is done in the system now. So they wouldn't have it, but you with the contract that any of you guys want, do not call the dealership for the contract. Let me say it again, do not call the dealership for the contract. Call the finance company because you want to see what contract they have. And sometimes they slip up and give you the right one and sometimes they'll give you the same one, but just call the finance company to get it. Okay.
Okay, and so the finance company would be my lien holder, right?
Correct.
Okay, all right. Thank you so much.
You're more than welcome. Shelton.
Hi, Queen. How you doing?
I'm great. How are you? I'm happy you were able to get on.
I had a question. You were saying for the FOIA search, and you said it was in what city again?
Atlanta, Georgia. It's the
Atlanta.
IRS location in Atlanta, yes.
Okay, and one more, we still on for that conference call with BOA? Bank of America.
Email me. I got a blank, and it's not because I forgot, but I deal with so many of those. I'm like, BOA, I'm trying to shuffle it through my head. But yeah, I'm gonna inbox you another email to send it to. I will not put it on here because everybody gonna try to use it. So that you could communicate with me through that one, okay?
Okay, thank you.
All right, you're welcome. Derek Spencer.
Oh wow, how you doing, Tamika?
I'm great. How are you?
It's a pleasure. It's a pleasure. I got a few questions. Let me get my notepad. All right, so excuse me.
I'm gonna answer all of them because it wouldn't be fair, but keep going.
I got you. Excuse me for my ignorance. It may have been in a previous class, but
is it about arbitration?
No, it's kind of how to deal with LexisNexis.
No, that would I'm only doing with arbitration, but the second part of the arbitration class, if you notice, all the big three, Experian, TransUnion, Equifax, and all of the credit agencies, they all have arbitration guys. So when I say that this arbitration is going to work in so many different aspects, including LexisNexis, so yeah, I'll be kind of covering the credit bureaus, the credit agencies and the reporting agencies in part 2 of this class. So that question will probably be answered there. But I will tell you, order your report and freeze it. If you don't do nothing else, order the report and freeze it. You want the report for proof of claim for when you go through arbitration with them to make them pay you for violating your rights under the Privacy Act of 1974. So anybody on here, next level, order your report first and then freeze the account.
Yeah, because they
You can ask me another question.
A lot of stuff.
You got any other question?
Yes. Okay. So arbitration today, because you actually sent that email saying had your contract. I called my company. Now I know I have this paperwork, but I gotta find it type stuff like the original. But I called them today and I said I want a copy of all my documentation. So they sent me a number of things. They sent me pay history. They sent me the most important thing was it. I think it says installment contract. Yeah, the contract. And at the top it say, this is a copy. This is a copy view of authorization copy held by the designated custodian. So how do I get outside of finding the actual paperwork? And I know I got it because I'm that type of person. I don't know what
They gave it to you. That's what they gave to you. So you'll accept what it is that they gave for you. There's a reason, guys, that they tell you to keep your documents for 7 years, and now you know why. Okay. They gave it to you. So any other thing that you're going to get from them will be when they do discovery through the arbitration, if you decide to do arbitration.
I had documents for like 20 years. No lie.
Get to finding your contract then, because you want, if you have your original contract and then you guys get a copy from the finance company, which I always say is wise for you to do that, you compare the two. Y'all heard me say they was 1 digit off, like literally 1 penny off on that from one paper to the next, and they had to pay her $50,000. Like, yeah, they had to pay her. So compare the contracts. Let's see. James.
Wait, that.
Hello, James. All righty, Howie.
Hello, can you hear me?
Hello.
I can hear you now. You're
Hey,
almost a
James.
mess. You lose your shots.
I'm sorry. Thank you so much for taking my call. So last time we talked in the last class, you told me to do bankruptcy. remove my case from state court.
Are we talking about arbitration? I'm only
Yeah.
talking about arbitration. That's it.
Yeah, yeah. And then, so she said, remove from state court, you said the bankruptcy and then the arbitration. So is that gonna be jamming me up if I do this federal case, removal and the arbitration? Or is it conflict, or is that confused me a little bit?
It depends on what your, I don't remember your exact case. I don't remember your exact case. So
yeah, so
I'm not exactly sure why I told you to do both. But I don't remember your exact case.
The judge
keep saying that because I
yeah,
don't know.
the judge put an order in for my arrest because I'm in contempt because I won't bring the vehicle back. So we did the bankruptcy to stop the contempt in the order.
Yeah, so yeah, you're gonna have to go that route. If you already got a judgment against you, you have to get the judgment stopped first. And if you already took it to court and it was supposed to go through arbitration, like I'm not exactly sure how that worked, but yeah, you will have to. I would definitely file a bankruptcy if you don't want to. But no, you have to do getting the order stopped because you already have order against you. And I would
Right.
really have to see like more of the physical court case in order to advise you a little bit more because court cases are different. And right now I'm booked up on court cases, so I can't even promise you when I'll have a chance to look at it.
Yeah, I have a conference call on the 23rd coming up.
Oh,
and
all right.
also-
I guess we'll talk about it on the 23rd. Then.
Yeah, the only thing is they put the order in on December 21st, the judge for the arrest. So I put the bankruptcy in already, but I wanted to respond to him on that order also, either with the arbitration or something to that effect, if that's gonna make sense. Or should I hold a second and talk to you?
Yeah, you're gonna have to hold that until you talk to me.
Okay, you got it. Thank
All
you.
right. You're welcome. D-A-R-E, how you pronounce your name? Is it Dare for real?
It's Dare.
Dare.
Dare, yeah.
It's who? Dare. Oh,
Dare.
that's like, wait, hold on, Dare. Hey, Dare, what's going on?
How you doing? I'm so happy.
I'm great.
I feel like I won the lottery speaking to you right now.
Oh, thank you. I ain't nobody special.
I sent you an email last week. So my question is, I have like 3 contracts right here. Well, one is a purchase sale order for 2 cars, and that has no arbitration clause.
Oh, that's what I needed. Can you email me that?
Sure.
So if you notice how all the numbers are just on that purchase order and it don't break it down by no finance charge or none of that.
Yeah.
That right there is what they actually sent over to the bank. I'm happy somebody got one so I can use yours.
I have 2
But
of
keep
them
going.
because I have 2 of them. Those 2, I got the one car November 28 or something, and the next one December towards the end as well. Those don't have arbitration agreement, but they with credit union, but it's from Mercedes. So I was thinking, should I have the information on SP and Global from for Mercedes, but I can't find anything with the credit union. So I'm like, should I be going towards the credit union route, or should I just go straight Mercedes since both cars is from Mercedes?
So, but you did the financing through your credit union, right? So you took a check. So you got the financing from your credit union, and then you took the check into Mercedes.
No, Mercedes did everything, and it's actually in my.
So if Mercedes,
it's actually not even in my name. I just co-signed for one of them. One of them was for my my wife, basically.
Okay, so since Mercedes did the actual deal as the creditor rangers that they are, Power Rangers, the creditor rangers or whatever. So yes, you will do it towards Mercedes because they're still using the credit union like it's a servicer, but they use, and I know Mercedes is US Bank and it's another one. They are the ones who transfer the contract. So yes, it will go through Mercedes, and you can still add the credit union onto it. And the reason you can add them onto it is because they're supposedly the servicer for Mercedes, and that's who they supposedly ran your note through. So you just add both of them onto the arbitration.
Oh, okay. So the other one is a van for my business, and I co-signed for it because they won't let me do it straight under the business. and that one has arbitration on it. And I already tried to do a rescission with them. It's with Ally Financial. I bought the car from a regular dealership, but they finance it through Ally Financial. So I'm thinking maybe now I should do arbitration, because I actually never saw it till today that it has an arbitration agreement after I got the email. I'm like, let me look at all these contracts again. So I looked and I saw, I'm like, okay, maybe I should go through arbitration with that one.
Yes, if the contract says arbitration, you have to, because if you do anything else, they can ignore you, because that's not what the contract said. The contract said you want to claims and defenses. See, what I do is, for y'all that's new on here, I don't create none of these processes. Okay, y'all know y'all got people talk about I created this process or here's this. No. Path to Freedom don't roll that way. Okay, and this is why Path to Freedom got as many reviews as they got. It's because we take their words, their contracts. You learn how to read it properly. That's where I come in at, to show you what you missed and to show you how to take those same black words on that white paper and use it against them for you to win. We're using their words against them, and we have the law to back us up, right? Because y'all have to remember, courts, they're not law. There hasn't been any lawyers, any judges since 1863. Okay, your local courthouse that they normally take you into is a private organization with a federal contract. They're not court. So it's telling you that arbitration, they can use the law and contract law and equity, right? So that's where you want to take them. You want to take them where you can use TILA. You want to take them where you can use the equity laws. You want to take them and use the law to back you up. If y'all want to win, I'm trying to tell y'all how to win. Okay, no ifs, ands, they gonna give in. Arbitration.
I'm actually going to court. They've been pushing it all year, last year. So my next court date is May 20 something, I think, or May 12, something like that, for another car from years ago that it was charged off. And
tell them to give you a proof of claim.
Yeah, that's what I'm doing
it
now.
off already.
They charge it off. I took it off my credit and stuff already.
So wait. Back. So they charged it off and it was on your credit. Do you have proof that it was on your credit as a charge off?
Maybe if I go back, I can still find it, but I took it off. I got it removed.
Okay, so if you can still find the paper that has it on there, and then you use the IRS publication that says that anything that is considered charged off is considered income. So they were supposed to send you the 1099-C because they charged it off.
I tried to call them for it. They say
they're not gonna give it to you.
Ends no more, because they have their attorneys, and the attorneys, once I start citing laws in court, they just kept postponing and postponing. And by the time I actually go to court, they can't even collect on it no more, because it's more than 3 years.
Correct. Do the FOIA, the Freedom of Information request for the location in Atlanta. Get a full copy of all the 1099s that has been filed up under your social security number, and then use that as evidence. But you can still, and then use that as evidence for that particular car. Okay.
Okay. All right.
Wonderful.
I have one more question, please.
Nope. I can't answer it. I'm sorry. I try not to do no more than two. I only try to do one, but I got too many people here, and I try to be fair, okay? Because after so long, my body tap out, and I'm like, okay, y'all, we done for the day. So save it for the next class. Emmanuel. That you was about to lean back in it, like, oh, and she didn't call me. Hey.
I'm so happy. Can you hear me?
I absolutely can.
I want to say thank you for real. And collab too. Big ups to collab, because I wouldn't even find the GOAT if it wasn't for him. So thank both of y'all. And I like to ask about, like, if you were to, I was like at the end of my contract, right? And COVID came out and I ended up losing my job or whatever. And then like recently in 2022, they came back and started garnishing my check.
Okay.
So they taking like 25%. They was getting like $500. They check almost like $4,000. Like, what is it a way that I could do something about that, like taking it to arbitration or anything?
It depends on the contract within itself. If there's an arbitration clause in there, absolutely. Because remember I said arbitration work both ways. So where is the judicial notice that they have the right to garnish your account? So the first place I would start at is with my bank. Tell your bank to provide you with the document that was sent to them in order for, I mean, not your bank, your job. You need the garnishment order, and then you'll start from there. At the point that you either throw it in arbitration or federal, depending on which one, depending on the contract, then that will automatically stop the garnishment. And then tell them to do a proof of claim. If you want the garnishment stopped immediately,
see, I don't.
Make sure you lock your LexisNexis. I'm telling you, I'm about to tell you what to do. Make sure you lock your Lexis report first. Okay, freeze it, security freeze, and then go file Chapter 7 documents. Okay, which is a bankruptcy, but you're not going to complete the bankruptcy, so it's not going to hit your credit report. At the point that you start a bankruptcy, they have to stop all repossession, garnishment activities, right? And then once you start a bankruptcy, the bankruptcy court is going to ask them for a proof of claim that they'll never be able to claim. So you can start there if you want to stop getting your money taken immediately.
Okay, but what if it's already paid? Like they done took everything they came for.
It's been over 3 years.
This just happened. I finished paying that in like November, October. And then
When was the original contract signed?
The original contract was signed in 2018, the end of 2018.
Yeah, it's over 3 years, so you got 3 years to claim any defenses on the violation of TILA. So yeah, you just chalk that one up. Sorry.
Even though they came in 2020.
It don't matter. It goes by the contract. The signing of the contract, you had 3 years to go retrieve your funds. So it was considered abandoned. So they gave the funds to your state, and your state now has it. And that's a whole process to try to get that from the state. So just chalk that one up.
I appreciate
it. Because I'm not gonna tell you to do nothing to waste your time. You know what I'm saying? Like it's been too long, and they're gonna use that law against you. They're gonna say, well, guess what? You had 3 years to tell us about the fraud, and you didn't. And you'll be wasting $462 to file that case. Okay.
Right.
All righty. You're welcome. Let's see. Marquise.
Hello, can you hear me?
Yes.
Okay, so I just had a question. I know it was probably answered earlier about the contract from the dealership. So when I got my car in May of 2022, they didn't give me a contract. And of course I didn't know any better. But they just gave me the car, they gave me the Carfax, and then I got a title in the mail a few days later. And then
you definitely have a contract. It's electronic. Just call them and tell them to give you the contract. You signed it electronically. So that's why they didn't give you the paper one. I can promise you they emailed it to you, but you didn't open it.
I just checked my emails and just called, and they didn't send me no email. So call the dealership first?
No. Call the finance company.
Okay.
The dealership doesn't have it any longer. Yeah, just call the finance company and get a copy of it.
Okay, thank you.
Okay, you're welcome. Mariah Brown.
Yes, ma'am. I think you just actually answered my question. I had just finished paying off my car note like less than a month ago, but I had originally got the contract in 2017, so it'd probably be too late, right?
Yep, it's too late.
Okay, thank you.
You have to take them to federal court at that point. You're welcome. Let's see. Miss Ruby.
Hey sis, about you. You know, I give you your flowers while I can. Just a quick question about the arbitration. So I'm still paying on my vehicle, and where I'm kind of confused at is we gave our rights for them to collect our securities. I know we don't want to like backpedal since we already. So how do we go about doing that? Even with our bills, like we sign those contracts, giving them the right to collect our securities. And I've read the Security Exchange Act, but just how do we approach them doing that?
The fact that the entire contract was fraud. So they got you to sign that contract under deceptive practices. So that is how we do it. And I'll be breaking down like all of the things to add within your arbitration in the next class. Yeah, I'll show y'all everything to add in there, including everything that TILA is included for. Like I said, I use all of their stuff against them. So in the next class, we'll actually be showing you guys a sheet that each one of you will get that breaks down everything that's supposed to be added with TILA, like the credit, life insurance, and the other things, and you'll use that to your advantage. So now it's just going about the fraud, dealing with arbitration and other instances. When you hit them with everything that I'm gonna teach y'all to hit them with, they're going to fold, y'all. I'm telling you, they're gonna fold. And that's what we want. We want them to fold so that you can get paid and, you know, come out on the winning end of it. It's just going to be non-disclosure agreement. And so if you want to like to run your mouth like diarrhea, I almost said gonorrhea, like diarrhea. I'm telling you now, you better start telling yourself, shut up. Don't tell, because you're gonna want to tell the world. I beat him,
So
I beat him.
So go ahead and file the 1098 just using the last month, because I've been, you know, it's what, 3-4 years in me paying the 402, but I just learned about this. So just do the.
So now the thing, if you're going to do the 1099A, you want to take it back to the original day of acquisition, right? So you want to take it back to the original day that you signed the contract. That way they'll look through the entire thing. But yeah, you can do that as well. But you can use that if when the IRS accepts it. You can use that a part of your arbitration to say, hey, the 1099A was filed. Technically, that's what we're supposed to do at the beginning of the tax year, guys. We're supposed to do that at the beginning of the tax year.
All righty. Thanks so much.
You're more than welcome. I don't know if you guys noticed that when I was talking about arbitration, I spoke of employment contracts, okay? So why would you be able to take your employer into arbitration? Do you know that your employer has insurance on you? Do you know that when you filled out that W-4 form, you're actually paying the business's tax for them? And then they're getting a write-off for every paycheck you do. So why would you take your boss into arbitration? There you go. They got insurance on you, number one. Life insurance. I ain't talking about health insurance. So there's a reason. I don't know. I've almost buried everybody that I've loved. So I've had to do this a couple of times. They make you put that ad in the newspaper talking about debt collectors. It ain't for no damn collectors. It's for them to be able to collect on the insurance policy. And the only way that they can collect on the insurance policy, due to the fact that can't just anybody get a copy of the death certificate, due to the fact that it is in the newspaper, it is now considered legal public notice. So they could take that newspaper article, send it on to the insurance people, say that he dead as a doorknob and let me get that check. And they do that for your bank account and every job you have ever worked for or apply that, whether you got the job or not. Because the application can be transferred to a third party. On one of the GMEI utility reports of a good friend of mine, me and her were shocked because one of the places was literally around the corner from her in Inkster, Michigan. And I'm like, what is this place? Did you ever go there? She said, I put in an application there. Every time you sign an application, it turns into a security and they sell it. That's why they say that once you put your social security on something, they cannot deny you credit. That is why, because your application can be transferred to a third party. Okay.
All right.
Let's see. Angela Pittman. I like your background. That's what made me pick you.
Thank you. I just have a quick question. So I'm still currently paying on my vehicle, but I actually bought it in 2018. I know it's over that 3-year period. Am I going to still be able to take them to arbitration, or is that a lot?
So let me elaborate a little bit more on this 3-year thing. Now, if you've already paid off your vehicle, you had 3 years from the time that contract was signed to go at them, right? On like federal charges. As long as you're still paying, that contract is still in effect, that means the arbitration is still in effect. So the arbitration doesn't have a time period. As long as you're still, you can do it. It could be the last note. Say your last note is due next month, right? And now you done came to this class, you can hit them with arbitration now. As long as the contract is not finished, yes, you can do arbitration.
Okay, awesome. Thank you so much.
You're more than welcome. Let me see. Let me go to this other page. Mr. Clemens.
How you doing?
I'm great. How are you?
Listen, I don't mean to interrupt the class, but when I first got on, I like your simplistic views of using their words against them. We all family.
Thank you.
You're gonna stay 10 toes down, but I need your 10 toes on top of my 10 toes. October. I understand that it's a movement had to take place and all of that, but I've been real patient and I don't want to put it here.
What I supposed to do with you? Just tell me. You good? I supposed to do something with you?
Consultation since October.
Okay, so yeah, you are one that got caught up in the rigmarole. So which one of the platforms do you follow me on? Whichever one it is, can you DM me right now? And I'm going to send you an email address. It's not the same one. Send me an email and I'll get you in this week, okay?
You breakout, breakthrough.
Breakout, that's fine. So just hit it on breakout so it can light my phone up real quick so that I can send you the proper email to email me at, and I'll get you in this week, okay? And I do apologize that you got caught up in the switching and whatever, but I'll definitely make it right for you, okay?
I believe you. Thank you.
All right. You're more than welcome. We keep it real in my class, y'all. I'm gonna tell you. So I had some changes for y'all that don't know, and a lot of things got misdone, and I'm just getting everything back together. But one thing about me is that I will never leave anybody hanging, and anything that's dealing with me or Path to Freedom, if I'm wrong, then I'm going to admit that and I'm going to make it right because we're all human. But I got you. I appreciate your patience. I absolutely do. So yeah, just send me a thing so my phone can light up now so I can send you the email and I'll get you in this week, okay? I work Friday for you because I don't work Fridays, but I work Friday for you. Let's see who we got. Hey, Boogie.
Good evening. How are you?
I'm great, and yourself?
I'm good. I would also like the gentleman I'm trying to get in contact with for the consultation for a while.
Oh, DM me on something and I'll send you the right email and I'll get you in this week, okay?
All right. I wanted to know how can I find the financing company? Because this guy does his own. So I don't know what bank he used, what. And I don't have the original, I don't have my original contract. He gave me this copy of retail installment with, it's just real basic, no signatures at all, not even my signature. Just, you know, my name is typed on there, but his name's still not on there anyway.
Is it an arbitration? Oh, well, he can just
Yeah,
say
it's
you're
an arbitration. It was an arbitration clause. So now, can I just can I start that like tomorrow? We'll put the arbitration in tomorrow. Claim tomorrow. I've been dealing with this guy too long.
If you put the arbitration in, tomorrow, what is going to be the reasoning that you're going to give the arbitrary company that you're taking into arbitration?
The part where he didn't do arbitration for me, he repossessed the car.
That's not gonna work. So let me tell y'all about arbitration too. If you don't put the right stuff to get the initial hearing, the arbitrary company can deny the arbitration. You don't want that to happen. Are you behind on your, not to ask you, if you ain't gotta tell me if you don't want to either. Are you behind? Are they coming to repo, or are you just mad as hell because he played you?
Yeah, I'm mad as hell, for sure.
Okay, so let me tell y'all about what mad as hell gets y'all, okay? So when you get mad as hell and you don't root yourself in foundation, some way, somehow you end up losing, okay? And what you don't want to do is tick him off, especially at this stage, depending on the type of company they are, because you don't want them to do a retaliation at you. You want to make sure that
the car for to repo the car in retaliation. It's all personal. It's all ego. I'm ready to kill this guy.
Oh no, not on the Zoom. What do you mean?
I mean,
kill me, Hub.
I'm not gonna kill nobody, but
kill me, Hub.
Is really like, he's a little dude. Oh my God. So anyway, I can't talk to him because everything is ugly. And
So were you behind on the car note?
I've been real patient. I've been real patient.
Were you behind on the car note?
Nonsense with him.
Were you behind on the car note when they repossessed you?
2 days.
So depending on
And
what
I
your contract
spoke to him prior to it. It's all personal. We spoke. I told him I was going to be late. He came and took the car because I told him the month before that, if you want the car, he's like, oh, we bring the car here and park it here. So you want the car, you don't have to come and take it. I'm not giving you shit.
Well, shit, you just told him that was an oral agreement. The hell you told him to come take it?
Come on, man.
I'm just telling you.
I'm making the payments.
Tell you why I said that.
It's not.
Okay?
It's personal. That's all I'm saying.
But listen,
it's an ego. It's an ego type of thing with this.
If it's an ego on the both of you sides, though. So let me tell you something.
I'm not ego. I'm paying him. I was paying him. I mean, I don't know what else I'm supposed to do.
If I was your arbitrary here, person, right? And you said to me, I told him to come take it, I'm gonna immediately say that you lost because that was an oral arrangement and you told him that he come and take it, which is ultimately considered a voluntary.
No. I'm just saying, he's telling me to come
I'm just telling you, you got to watch what you say.
I understand what I'm saying. You can't tell me you're gonna repossess, you want me to bring the car to you or you're gonna repossess the car. It can't be both ways. If you want the car, you have to repossess. I'm not gonna bring you the car. Why would I do that? I'm paying for it.
So in the contract in which it is that you have with him, what is the late payment clause? Because there's a late payment clause in there. So did it say that once you one day late, they can come and repo?
I don't see one in here, but either way, you said we got the arbitration. You're supposed to go through the arbitration to do it.
That is true.
So he didn't do that.
Okay, well, we have to talk about that on your what you call it, because you're.
So how can I find out his finance?
You would, depending on if he doesn't, is he a buy here, pay here?
Yeah, you say
okay,
that.
so you have to hit him totally different because he's a buy here, pay here law. So he doesn't more than likely have a trustee, or if he do, is buried. But like these little P-lots and things like that who do that, they don't have access to the securities in which it is you think that they do. If they have no bank backing them. So they have to have a trustee, and it has to be a institutional trustee with the T6 form filed at the Security Exchange. So if he does not have any of that, the only thing you will be able to do is either do it through arbitration or federal court. But we can go on more detail because your thing is a little bit more complex, but I'm gonna tell everybody on this call this, okay? Yes, this can be, you go through the stages of grief when you find out about how you've been played. And then you get to a stage where you get mad as hell. And then you're gonna get mad as hell and you're gonna allow your ego and you're gonna rash out and you're gonna go after these people. No, that's not how this works.
I'm cool with all that.
I'm just making mute. Somebody mute for me, please.
Oh, I'm sorry.
When I'm speaking, I'm speaking. Like,
I'm sorry.
We're not gonna do that. Thank you. I'm just advising you. Listen, you cannot go at none of these people in emotion. This is not about emotions, it's about contract law. It's not about emotion, it's about equity. I understand that you say he did it out of what you call it, because you was probably talking to him crazy and that nigga got one up on you, you was late on your car note. Point blank and period. You told him to come take it, he came and he took it, so now you at this point, what is it that I'm supposed to do? Well, the first thing I'm gonna tell you to do is get out of your emotion. Get out of your emotion first. You're not gonna be able to do anything in emotion. I'm trying to help you, okay? You beat these people by understanding what they did wrong and you do it the proper way. So if your contract says arbitration and he didn't take you to arbitration, yes, you can file that. But you better make sure that you got everything in there because you do not want the arbitration hearer to deny you even doing arbitration. If y'all do some paperwork, talking about some 15 USC 1692 or some violation of TILA, if you do not go into detail and they deny your arbitration, then what are you going to do? If arbitration is in your contract, and what are you going to do? Because if you can't get through arbitration, I keep telling y'all, you're not going to make it through federal court. They're going to immediately throw it out before it even get in the door. So the first thing y'all do is just take the emotion out, take the egos out, and look at it for what it was. we allowed these people to play us because we wasn't fucking read, period. You want to be so mad at this company. They defrauded me. No, your ass didn't read, period. And then now you're in a situation where you like, I need it fixed. And the only thing that's going to help you get out of it is by reading and knowing their policy and then sticking it to them, using their own words against them because they cannot rebut their own. Okay, just a word otherwise. Emotion is going to make you lose. Foundation is going to help you win. Okay, but we'll talk on your meeting. Just DM me somewhere so I can send you an email. So, let's see. Mr. Hernandez.
Thank you once again.
You're welcome.
I am also trying. I'm pretty new here. This is my third class, I believe. I'm not sure if that's new enough, but regarding the private consultation, I'm sure that you're booked up, God knows how long. And I was trying to push for that. I was sending emails on the Path to Freedom email address, but now I'm hearing that you have another email and stuff like that. The only thing I have on social media is TikTok. I don't have anything else, Instagram and stuff like that. I'm pretty disconnected with the world. I'd like to keep it that way. But I don't know what other way to find you, to DM you or whatever.
Was you supposed to have a consultation or are you trying to?
I'm trying to get a consultation.
Okay, it's whichever one, if you follow me on Breakout or even TikTok, is a link in my bio. I can tell you that I'm off until it's like the end of January. I think I'm booked up too, but I don't know for a fact without looking at my calendar, but the link is in my bio.
In your bio where?
On TikTok, Instagram, and Breakout.
The one that's Celeb, because I went through Celeb. I didn't go through you. I found you through Celeb.
Through Caleb.
From Caleb.
Okay. If you go to Caleb page, it's Path to Freedom 2023.
Path to Freedom 23.
Yeah, 2023.
Path to Freedom 2023.
Yeah.
Now it's path number 2 to freedom, right?
That is correct. That is my copyrighted trademark name. It belonged to me.
So
spelled just like that with the number 2.
And that's on TikTok, right? So I'll follow you. I guess you follow me back and then we can message each other, right?
Probably so, but I get so many messages and I promise y'all that I stop answering because I be busy.
Yeah, if you're not following me, I can't send you a message whatsoever unless I get you on one of those messages.
No, but you can go on the link in my bio and set up a consult though.
Oh, okay, that way. Okay, cool.
Perfect.
Thank you.
Lisa, regardless, you're welcome. Hello, Miss Lisa.
Hey.
Hello, darling.
All right. So I don't want to go over the amount of questions I'm able to ask. But what I was trying to do is I have numbered I guess a list of things that I'm going to do as far as the arbitration goes. And I guess I just kind of want you to let me know if I have this in the correct order according to the demand for arbitration. So when notifying the AAA of the claim or the consumer contract, I heard you say that we should not send that contract in the beginning. We wait until after, let's say BMW has sent in their information. Now, with that being the case, it said in the rules that we were to notify the AAA along with, I guess, anyone that's going to be involved. So would that be looking at, if I look at the BMW Vehicle Lease Trust from S&P Global, they have about 8 or 9 different entities that are listed here. Am I going to notify all of them of the arbitration, or would it just be the BMW Financial NA LLC, which is the lien holder?
It'll be several, depending on who you got the contract through, who their trust indenture is, who their indenture is. So a lot of variables going in that, but I'll be going over that step by step on the next class.
Okay, gotcha. Understood. Okay, now The second question I have, so it says to provide the AAA with only a copy of the arbitration portion of the retail installment contract. So can I just take out that page and just send that over?
Yes, ma'am, you're still correct. You still have to follow their rules. They have to see that there was an arbitration agreement in place in order for them to take your case. So yes, you can send them that page and that page only.
Okay, that's perfect then. That makes sense. Okay.
All right.
Yeah, I think that's
And I
about
would
it.
advise you not to do that arbitration until you get the second part of the class, but y'all can do whatever it is to choose if y'all want to, but I would just tell y'all like this, if y'all jump out and do this arbitration and then you get stuck and then you call, I've had people text me, I got arbitration tomorrow, can you help me know? They get either a no or I don't even answer them. So I will make sure that I have all of the pertinent information because as I've said once, you have a one-stop shop with arbitration. You got one shot to get this correct. One.
Yes,
So
that makes perfect sense.
y'all decide.
I'm not gonna
yeah,
move
y'all
forward.
decide y'all want to jump out. Yeah, I wouldn't. And my assistant with arbitration is $1,500. So y'all better do it right. Because if you need me to be on that phone, you're gonna pay me $1,500. That's how I know I make sure y'all do it. Some people be like, fuck it, I'm paid. And I ain't gonna tell you I ain't gonna take it. But if you want to jump out there in arbitration and you're gonna need half the freedom's help, I'm gonna need $1,500, okay? Latanya?
Hello. Can you hear me?
Absolutely.
Hi, how are you?
I'm great, and yourself?
Awesome. Quick question for you. Are you taking questions on any air disputes?
On any who?
The air disputes.
No, I'm only on arbitration tonight. I realize taking questions on other things cause people to get confused, and this year I'm sticking to the topic. So no, not on air disputes. I will not.
Okay. I got you. Okay. Thank you.
No problem. You're welcome. Alexander Hazel. But if it's anything with credit report, hit Caleb. I don't do credit anymore. Hit Caleb.
Yes, hello.
Hi.
Hi. I'm shocked you picked me. But I had reached out to the finance company for my contract, and at first they were telling me they don't have it and that they can't send it. And I was confused because it's my information. Why can't you send my stuff? But they end up sending me the encrypted version. Now the encrypted contract had the manager, the general manager's signature, but I was the last person at the car lot and everything, and it was just me, my sales agent, and the finance rep. But I'm not sure why his signature was on the contract, and I signed multiple pages.
Is it on the left or the right hand side?
It's on the right hand side.
You got an arbitration agreement? Do
Yes.
you have your original contract? Y'all better stop doing stuff
I'm not
like-
sure if it's original. It's yellow, it's 2 pages. It's yellow
Right.
pages.
No, you got the one that they gave you when you got the physical vehicle?
Yes.
Compared to two, but you can bring that up in arbitration. If y'all notice on some of them papers, they have y'all sign on the left, and then some of those car papers, they got y'all signing on the right, but it's the same packet. Yeah, that's because they're going to commit that fraud with that, and it's going to make it look like it was 2 signatures on there and it wasn't. Oh yeah, they go real deep.
Right, because
But
at the lot when I was there, I was signing multiple pages, but it wasn't always on the right side.
Yeah, and that's why. It's crazy, isn't it? But when you know what to look for, y'all gonna be looking at contracts all upside your head because you have to operate in public and private. So it'd be hard for me when I'm doing stuff because I'm like, I know these people is, but you just gotta let them do it, and then possession is 9/10 of the law. The goal is for you to get what it is that you're went in there to get, and then you hit them on the back end. That's the best thing I could tell you. And for now, y'all, please keep y'all contracts. Keep y'all contracts. They say 7 years, keep your documents. Okay.
All right, thank you.
Let's see. Zealy, you're welcome. Y'all got 10 more minutes and then I'm done with the questions and answers. I absolutely can.
Okay, so I have a question in regards to the FOIA when we requested through Atlanta. I did find, I'm not sure if this is the one we follow, but is it the one 31 CFR? Do we follow the rules in that in regards to how to request it?
Or a freedom of information request?
Yes, for the one in Atlanta.
If that's what their rules say, yes.
Okay, because it's kind of confusing because they talk about the electronic room, but then they also say to send a written to Atlanta.
Yes. A freedom of information request has to be written. You
Okay.
have to sign it, you have to get it notarized, and it has to be written for you to send it. If you call them asking for it, they do not have to give it to you.
And we just write it up basically saying that we're requesting all documents that they have.
Based on how the FOA is supposed to be written. Yes, they might even have their own form for it. Might want to look.
Okay, thank you. I appreciate
They might
it.
have their own form for it. It's been a minute, but they may have their own form for it. But you're welcome. Just make sure you put any and all documents related to Social Security number, blah, blah, blah. You can actually write on there any and all 1099 A, C's, B's, F, G, HIJ, elemental P, like put them all down there so that you can be, so they'll know exactly what it is that you're looking for. Don't just say all documents, like name the particular documents and what it is that you're looking for, because the IRS publications say whether you know it or not, you are responsible for all charge-offs because it's considered as income, and you're technically supposed to put it on your tax return. So they actually filed it.
Okay, I appreciate it. Thank you.
Not a problem. Brandon, you've been trying to get my attention. You got it. Hey, Brandon. Look, you know how to get my attention, didn't you? You did all that night, you ain't talking. Going once. Going twice. Mr. M. Mr. M.
Hi, how you doing? Quick question. I heard you say 1,500 to be on the phone with me. So how do I go about that if I wanted to do that? That's the first question. And then
set up a console with the link in my bio.
Okay. And also I have my contract in front of me, December 23rd, 2019. So statute of limitations is 3 years. So would I be
still
out?
paying on the contract?
I just paid it off about 4 months ago, fortunately. Yeah, so am I out or
yeah.
Am I?
Yeah, the contract is over 3 years old and you just paid it off 4 months.
Yes, literally by 2 weeks. And then also, does that nullify my down payment as well? Is that something separate?
No, I mean, it all could have been done within the same time period. The thing is, you don't have an active contract any longer. So if you don't have an active contract, you don't have an active arbitration agreement. Okay. Now, the way that you can get them is if you do the FOIA and get all the 1099s that was filed in your name, and once you have physical proof in your hand that they actually discharge that debt off a year after you got it, then yeah, you can hit them that way. But I will make sure that I got solid proof in my hand before you try, because you voided, there's no more arbitration agreement because the contract is void.
Okay, great. Yeah, I have like a 27,000 down payment I wanted to recover. Okay,
ooh,
no problem.
Ooh, there's a way to do it, but
I got a nice fat one
take
for
a minute.
You. Yeah. Okay. Wonderful. I appreciate your time. Thank you for everything.
It's my pleasure. Let's see. Wait, nobody hand them down this way. Let's see. Sarah. I like your hair. That's why I called on you. It's cute on your picture.
Thank you. How you doing?
I'm great, and you?
I'm doing good, thank you. So with my situation, they just literally January 7th charged off the car, and I still have the car in my possession. As far as I know, they only made one attempt to repo, but not like I mean, not even with a tow truck or anything. They just came and put a some kind of notice on my door and like a private investigating sticker or whatever, and I had to call, and they said they wanted to come repossess the car, and I told them they don't have permission. I hung up the phone on them, and I never heard from them again. And so yeah, I'm looking at my contract too. I don't have an arbitration agreement on my contract. And mine's
who did you get your car from?
I got it from Henderson Chevrolet. and it was I said 2022 Chevy Silverado, and I just got it in
It's
brand new.
You got it when?
In April last year, and they just charged it off like on the 7th of this month on my credit. Like it just popped up and said that they charged it off, and then it deducted the amount like $49,000.
But they didn't never repossess the car.
No, I still have it in my garage.
Girl, I'll keep that back in my garage. Okay, what you trying to do?
So
okay, so in their case, you have to file a federal lawsuit because your arbitration, of course, is over. So you can file a federal lawsuit, which will stop the repossession of it and take them to federal court. You can do that under securities fraud. I would threaten them first with the cover sheet letter. Do you got the title?
No, I was gonna do what you said as far as like pull up my motor vehicle history and then show that it's proof of registration because it's still current in registration and in insurance, and then send that to the manufacturer to get the MCO.
Correct. The MCO should be in the back of, because that's a 2022. So the MCO should be in the back of your motor vehicle report. It should be all the way in the back. For y'all who don't know that, your head title was given to the DMV. You remember I told y'all that the car was first bought off the lot because they sold the title to the DMV. So your MCO title will be in the back of your motor vehicle report. So it should be already in there. If I was you, I would make sure, because they're trying to come and repo it, I would lien it. So file a UCC1 and lien it for 5 times the amount of what the car is worth. So that way, if they do try to come repo it, they can't sell it until you take the lien off.
Okay.
Okay.
Okay, thank you.
You're welcome. Ms. Roxanne.
Hi, Tamika. Thank you.
You're welcome.
I'm not showing my face because I'm working. Anyway, I was thinking, would this work for someone who has had their property? Reason why I say stolen is because there are so many storage facilities and places around the world where they just underhandedly sell people's property. So because it is a lease agreement, even though you're not living there, could the arbitration be used in this particular incident if, you know, you have your belongings there and then they repo the belongings because you didn't make payments?
Is there an arbitration clause in your agreement?
Well, I don't have it. As one of my relatives who took her.
You only could do right. You only could do arbitration if there's an arbitrary clause within there.
Okay. Okay.
Okay. So they would definitely need to see if arbitration clause is in there.
Okay. So if it's in there, it doesn't matter as long as the arbitration clause is there, and it is a lease agreement and it's for a storage unit. So just wondering if something like that would work. You know?
Yeah. Just read over the main key, guys, before y'all start anything. Is just read over your actual contract. Okay. Yeah. As y'all showed y'all, your contract is going to tell y'all everything. It's going to tell you what to do, how to do it. For you guys that missed the beginning part, I don't think Tracy's in here. Tracy Lynn, are you in here? I ain't seen her, so she must not be. So when she was able to get her PO, her American Express, for you guys that was on the do not pay, do not collect status class, no, which class was the billing error class, which was do not pay, do not collect status. We showed you guys the proper stamp that you need to place according to their rules on your statements. She did not mail it to the trustee. She read on their website where they say to mail additional instruments, and it worked for her. So y'all always start with your physical contract, start with their terms and conditions first, use their words against them. They cannot rebut their own words, okay? They only can comply, but they are used to us not knowing their words or not knowing what their physical meaning of the words are, okay?
Right. One other question, real quick. In the near future, will you be opening up your private banking classes anytime in spring sometime?
I'm not sure. I got a private banking class that starts tomorrow that I'm actually restarting because everyone that was supposed to be in there is not in there. So I'm starting that class tomorrow and it'll probably run until, what's this month? January, February. If I do, it'll be sometime in after May, April or something, once this class is over.
Okay, so you're not accepting new people right now, right?
Okay. No, ma'am. I keep that class. I have to keep it to a certain level of people. It's very small.
Because I'm doing private banking now too, but I just could have used some extra help, but that's fine. I'll wait till the next one. I appreciate it.
Okay.
Thank you.
You're more than welcome. Let's see. Tori Martin. Going once. Going twice. Down. Latanya Bryant.
I'm unmuted. Can you hear me?
Yeah, I can hear you.
Great question for you, Tamika. What happens if you're denied arbitration? The company offers it. It clearly tells you if you're unable to resolve your matter via dispute. And I know you said no dispute, but it kind of goes hand in hand with the arbitration. They're saying that this is a final business decision. So they're not offering arbitration, but it's offered.
Who said is?
This is Verizon.
Verizon definitely has it. So when you tried to do the arbitration, who did you contact? Verizon?
No, I haven't done it. I haven't done it yet, but I just got the letter in the mail. I actually sent it to your inbox so you could see it. But I just got the letter today.
Yeah, probably not gonna look at it.
Yeah, that's fine. But I just sent it to you. Denying actually an arbitration, saying this is a final business decision.
So this is my question. When who did you talk to? What did you send them in order to get that type of correspondence?
So I sent them the billing air dispute, just as we, discussed in class. Everything you told me to send is what I sent them.
And you sent it to Verizon?
I sent it to Verizon on the billing dispute in Jersey.
So that wasn't a bill. That's not an arbitration.
No,
you just sent
not
them,
an arbitration. Right.
Correct. But, so Verizon has an arbitration agreement within that contract that you signed. You're going to have to take them to arbitration.
Exactly.
Yeah,
so,
all of that business decision, they base it off of whatever you sent them. Now, the thing that's what's going to happen now is that when you do file for arbitration, they already know which way you coming. So I hope you came strong as hell.
I'll
You
send it
already
to you.
sent them everything.
Okay.
Okay.
Okay, thank you.
You're more than welcome.
Okay.
Serena.
Hello there, can you hear me?
Mm-hmm.
I have a question with, I know this arbitration, you mentioned UCC1 filing. Since we're talking about the cars, I had done one on a car that I had not secured financing for, and I wasn't sure of the next step. I probably shouldn't have done it, but I did file one on a car that I'm trying to obtain.
Who told you y'all can do that? You know that's fraud, don't you?
I did.
How do you have a interest in something that you don't belong to you?
Okay. Okay.
Yeah, that's
so what
fraud.
should I do now?
Leave it alone. Withdraw. Do a UCC3 and withdraw.
UCC3.
Yeah, and withdraw quickly before they hit you with federal charges. A lot.
Okay.
Like that's not the way. How long you been in my class? For a minute. You already know you got to do public and private. Okay. You know you got to go in there like a regular person. Get the contract, and then at that point discharge it, like the proper way or however you're going to do it. But I don't know why people got y'all believing you just about to walk in the car lot with some 1099s or follow some UCC1s and things like that, and then they're just going to hand you over a vehicle. It does not work that way. For you guys that are new in the class, I did these classes in order. Okay, I did them in order. The very first class that I did was the recording your national status. Okay, I know everybody want money. I know everybody want things, but where's the freedom that you're supposed to have, and which it is that the Creator gave to us. So you first initially have to start with correcting your status. Excuse me, putting your status on the record properly. Here at Path to Freedom, we put the classes in order. So the first thing is to get out of their federal and state jurisdiction, which was held in the Recording National Status Studies. The second class was credit. You have to be able to go and sit down with these people for them to even offer you a consumer credit contract, for them to even commit the fraud, for you to end up to turn around and get the items. There is no half stepping. There is no shortcuts. It does not work that way. Okay. But the classes were done in order on how you're supposed to do it. This is why we're at the do not pay, do not collect status now. But yeah, they're in order. So for you guys that just started, for you guys who don't have your status corrected properly, the information is there. Like, y'all got to stop trying to skip over things or trying to get shortcuts with things. Unfortunately, if that was the case, everybody be filing a UCC one on houses, cars, and then be obtaining them. Okay, it doesn't work that way. I'm sorry. Okay. All right, I'll take one more. Who have I ever talked to? Malachi and Heather. It's your turn. Come on down. You the next contestant.
Hi.
Hey, boo.
You can hear me all right?
Yes, I can.
Awesome. We want to say thank you from the bottom of our hearts. We are.
You're welcome.
No.
You're breaking up. I can't hear you, Heather.
Is that better?
Yes.
Okay, I'm so sorry about that. Okay, so my car contract started February 23rd of 2019, and I just got repossessed on Wednesday the 4th. I can still do arbitration though, is that correct? If the lease isn't finished?
Correct.
Okay.
Because they just repossessed you. So yes, I would hurry up and put it in arbitration.
Yeah, I will
So
wait for that
that'll
next
stop them from
class till
selling
I
it.
have it all.
Perfect. Yeah, that'll stop them from selling it. And then that way you can go through the arbitrary process. So they'll still be actually physically holding the car.
Okay, so should I wait for the next class for part 2, or should I go ahead and throw it into an arbitration status from our class tonight?
I would probably wait to the next class, and unless you feel as though that you're sufficient enough to be able to do it.
Right. Okay.
So
Yeah,
that will
because
be up
I
to
know
you.
they said within like 10 days-ish is when they would start looking at like selling it. So that's okay.
It takes a little bit longer than that.
Okay.
They tell you anything so that you can hurry up and give them a payment.
Sure.
But I would definitely follow UCC 1 on there, and so that they can't really do much or anything. And then during the next class, it will show you exactly how to file the arbitration to make sure that they, 1, don't throw it back, and 2, that you have enough leverage that you won't have to go no further, and they'll try to, for them to settle out with you in private.
Okay. And then I missed what you had said to ask for in the step where we tell them what it is that we want to settle with the repossessed vehicle. I know we can't necessarily ask for the title, you said, but I missed that part.
Yeah, not if you don't, if they've already repossessed it, you can put in an arbitration clause for them to give you your car back.
Okay, to get the
That
car
could be
back.
one of the things that you can ask for as well. We will be going over that next week. The legal and the lawful things that you are entitled to when they do violate the contract, so that y'all won't be asking for crazy things like $100 million trillion and stuff from these people, because it just ain't gonna work. They're gonna file it as frivolous on that part of it. Okay.
Yeah, definitely. Well, we thank you very much for everything you do for all of us.
It is absolutely more of my pleasure. Okay, y'all. So like my energy is now depleted.
I feel you.
It is about that time.
Yes, it is about that time. I am sticking to my little thing in 2023 because I will just stay on this line the whole time until I pass out. So, but I'm not going to do that. The recording of this class will be coming to you guys. The way that the recording will be coming, it will be coming in the little back office thingy that has the PowerPoints, some additional information that we did not go, or we will go over, but that information will be there as well. So when you receive the email, it will tell you how to access it. Okay. Now, the way that the email system works, I can see if you got it. I can see what time you got it. I can see when you opened it. And when the announcement comes out that we say that the email has been sent, do not immediately say I did not get it before you go and you look for Everybody email is in one server and it goes out at one time. If your email ain't right, that's your fault, and you go fix it. Because somebody's did bounce back. And I'm not about to try to take the time to find out who it was, because that's not my prerogative. Seriously. So the best thing that you guys can do, will read your agreements, go through your agreements, look at the arbitration clause. Some of them got a particular arbitrator that you have to use. Some of them have one that you can pick your own. Like, there are several mitigating factors, but you need to know according to your particular contract. I will say this, even though I know somebody gonna do it, they're gonna jump tomorrow and try to file arbitration. And I'm telling you now, if you don't know what you're doing, just 2 more weeks, 14 more days, the next class, it can literally hold off because you want to get it done right the first time. You guys will have all of the leverage that you need to get what you want from them, which is ultimately a free and clear car and your money back. And it ain't just the down payment. It ain't just the finance charge, but remember, the finance charge is the sum of all charges. So if the car was $72,000, then that means that it's $72,000. But you're going to have to make sure that you have enough compelling arguments in order to do it. And no, I cannot be on the phone with every single person because I am only one person. Okay, Caleb is only one person, So don't be like, oh, Tamika will do it. No, you got to at least try. But that's what we're here for. We're here to help you know how to fish, because every single contract that you have ever signed, for the most part, has an arbitration clause in it. So like, when it's time for y'all to collect the bag on the inquiries and the things that is on your credit report, guess what you got to go through? Arbitration. Because y'all didn't even know that LexisNexis, TransUnion, Equifax, and all of them have a arbitration agreement in there. So when y'all see your credit report and it says promotional inquiries at the bottom of it, you know what that means? That if you got a Capital One and it says promotional inquiries at it, right? That means that Capital One was given permission by TransUnion to take a sneak peek of your credit report, and that's how you got a pre-approval in the mail. But did you give them permission to do so? No, that's $1,000. So if you got 6 of them on there, $6,000. But if you want your money, you have to take them through arbitration. Okay, that's why we're spending the entire month on arbitration, so that y'all will be ready when the time is up. Okay, so on that note, thank you guys so much. I will see you guys in 2 weeks. All my banking people, I'll see y'all tomorrow. Yes, tomorrow, Lena. If you're supposed to be in my banking class and you did not make the banking class, somebody just send me a DM, because some people was missed, but we are starting it back from the beginning. But send me a DM on a platform. Do not send it to the email, because it's just not gonna work. It's not gonna work. But send me something so that I can communicate with you on that, to make sure that everybody is where they're supposed to be. Once again, me and Caleb appreciate every last one of you guys went in tonight to get this education so that y'all can step on the necks of all these corporations. I appreciate you guys. I'll see you in 2 weeks. You guys will have the recording. Give me 48 hours, which means do not be texting me tomorrow talking about where's the recording. Because as y'all know, I got to take out snoring. I got to take out urine things. I got to take out a lot of stuff. So give me a minute. But y'all will have it within 48 hours, along with access to the PowerPoints and all of that good stuff to be prepared for the next class. And on that note, we don't chase, we'll chat. Everything that we want will come to us. And y'all have a good night, okay?